Good morning, everyone. Our first case up for oral argument this morning is United States versus Rivers and Tucker, number 23-1781. Good morning.
Good morning, Your Honor. May it please the court, Elliot Louthan on behalf of LaDonta Tucker. LaDonta Tucker's appeal concerns 924C and what Congress carved out when it added the limitation "in relation to" in the statute. Now, when the Solicitor General argued Dubin before the Supreme Court, the SG took the position that "in relation to" should be read.
Mr. Louthan, what's the standard of review?
The standard of review is a typical sufficiency of the evidence challenge.
How I want you to explain how we get there. I don't see this any other way than plain error. Because the way here's what I want you to tell me I'm wrong on. Okay,
Sure.
explain to me how I'm wrong. What I think you're saying is that when a defendant gets up in any criminal case at the close of the government's evidence and says, "We've moved for a directed verdict," and then if the defendant puts on a defense at the end of the defendant's case, says, "We move for a directed verdict," everything is preserved. Even though they didn't make any objection to the jury instruction, and at least to me, that cannot be the law.
Although it may feel counterintuitive, I believe that is the state of the law.
And show me how we weave from sufficiency of the evidence into the legal issues in the jury instructions. So the district judge, totally unaware that there's a legal issue in the jury instructions because there's no objection to the jury instruction. But it all then boils back to the one little phrase, "We move for a directed verdict." And every defendant, I think it's like you're incompetent if you don't move for a directed verdict at the end of the government's case, right? Every defendant does in every single case.
That's right. And so this procedural posture treads the same path as Dubin. And there, if in oral argument, the Solicitor General clarified that a jury instruction challenge is separate from a sufficiency of the evidence challenge.
Are you challenging the jury instruction?
No, we are not.
Okay.
We're just challenging the sufficiency of the evidence, which implicates de novo review under the familiar Jackson v. Virginia standard, where the evidence is viewed in the light most favorable to the government.
I don't want to stop you from answering Judge Kirsch's question, but mine is similar. So you're not challenging the jury instruction.
Correct.
But you are challenging the in relation to law, and you're attempting to do that through an appeal of the Rule 29 sufficiency of the evidence.
Correct.
Which seems like it's a backdoor way of getting around failing to object to the jury instruction.
It very well could be characterized as that, but on the other hand, that is what this court has, that this court's case law has.
What are you relying on for the ability to be able to legally challenge an issue just based on a bare bones move for insufficient evidence at the end of the trial?
So this is the same posture in this circuit as U.S. v. Castillo, which is a 2005 case. And there, the sufficiency of the evidence was reviewed de novo. The jury instruction there was reviewed for plain error. We're simply not raising the jury instruction aspect because.
But in that case, the sufficiency was addressed, but it was an evidentiary issue, not a legal issue tangled in. I understand you're saying the evidence was insufficient here for in relation to, but you're also tacking on that the in relation to legal aspect was wrong.
And that was a key feature of Castillo as well, because that case similarly was a possession in furtherance of, another prong or way of committing, violating 924C. And there was legal analysis there as to what in furtherance of meant. And so same here. We are simply asking that this court engage in statutory interpretation, which is reviewed de novo, as to what in relation to means, and then applying that under the de novo, but Jackson v. Virginia standard, where the evidence is viewed in the light most favorable to the government. But in terms
Castillo, they did object to the jury instruction, correct?
No.
On appeal, they were.
Oh, yeah.
Yeah.
Correct.
Which is why I asked you, are you objecting to, are you appealing the jury instruction? And you said no.
Right, because we think that we can win under the same, or that wouldn't change the outcome. And again, the whole impetus for this appeal was the Supreme Court's decision in Dubin. And so there's a strategic decision to follow the same procedural posture as Dubin. And just as the government in that case said, no, a jury instruction challenge is separate from a directed verdict challenge, that's the same path we're taking here. And so to get back to what the legal standard actually is, in Dubin, the government took the position that in relation to means the same thing in the aggravated identity theft statute as 924C, and it quoted Smith for the proposition that in relation to equates to facilitating. In other words, the official position of the U.S. was that in relation to in Smith is facilitating. We think that the court should heed that guidance in this case. Not only
But the
does
Supreme Court in Dubin specifically said that their ruling there does not change its 924C precedent. So how do we get around there?
That's
You're
right.
asking us to change those.
No. So if we think about a causal element like in relation to, which there's a wide spectrum, right, on the of how tight or malleable the standard can be. On the most malleable end, on the loose end, we have this potential of facilitating standard. On a far more rigid end is what the Supreme Court adopted in Dubin, which is at the crux of the underlying criminality. I'm not asking for this court to adopt that standard. I'm asking the court to just hew to what Smith originally held, which is that in relation to means facilitate, which is somewhere in the middle. And so to that footnote's point,
If it does your client still lose?
If
If it does mean facilitate instead of potential to facilitate, does your client still lose?
No, we went under the facilitate standard.
Why? Based on the evidence here? Because the gun was never displayed?
Because yes, well, that'd be part of it. The government did not articulate any sort of viable theory below as to how this gun, the gun that Tucker carried, facilitated the crime. All the government said below is that they wanted to be successful, and that's far too level of a level of generality. Now on appeal, the government offers this theoretical means of protection, but that too is far too malleable. Not only did the government not advance that below, but here there's a difference between a theoretical means of protection and evidence that the defendant actually intended to protect himself or protect in order to facilitate the.
But what would be required? I just am curious as to the difference. Like, let's say he wore the gun on his hip, like a cop. Would that facilitate the carjacking?
Absolutely, and we have cases like that. That's Patterson, that's Haynes. And there, the facilitation is that the gun is used as an indispensable prop, and that's a viable, articulable theory where non-specific evidence supports that theory. If the government had introduced evidence that he was aware that the victim would be armed, right, and he was worried about that danger, I think that's a different world.
And counsel, doesn't Smith tell us that the potential to facilitate is something we look to as well?
No, absolutely. I recognize, and in my rebuttal, I'd like to answer and then reserve. The potential to facilitate discussion comes in the context of the Ninth Circuit's recount of the legislative history. And you can't square that potential of facilitation discussion, if that is the operative legal standard, with everything else in the opinion. Nor in the subsequent 924C cases does the Supreme Court ever refer to that. And finally, I would again point to Dubin and the position that the United States took in that case.
Thank you.
Thank you.
Mr. Jerkosin? Good morning.
Good morning, Madam Chief Justice. May it please the court. My name is Justin Drykosen. Today I represent Aniko Rivers. The government agrees that Mr. Rivers' case should be remanded for resentencing under 4A 1.1E. The amendment is retroactive, so I'd like to focus my limited time today discussing the reckless endangerment during flight, 3C 1.2, whether that ought to have applied to Mr. Rivers' case. Here we have the context of a car chase, and it's undisputed that Mr. Rivers is the passenger. In every other circuit, in a reckless driving contest to consider whether a passenger ought to receive a 3C 1.2 has said there's got to be evidence of direct or active participation by that passenger in bringing about the reckless conduct by the driver.
Mr. Drykosen, are you challenging the sufficiency of the district court's factual findings? Or are you just challenging the legal conclusion that this isn't reckless endangerment?
Yeah, not necessarily. I think there's a, right, it's clear error.
Okay, it's got to be a yes or a no.
Fair enough.
Are you
Then-
challenging the district court's factual findings as to the reckless endangerment enhancement, or just the legal application?
No, Your Honor, we're just challenging the legal application, basically that the district court's findings are not sufficient as a matter of law in order for a passenger to receive a 3C 1.2 enhancement, and that's a de novo review by this court. You know, if we look at application note 5, that says that a defendant can be responsible for his own conduct and the conduct of his driver or other defendant if he aids and abets, counsels, commands, induces, procures, or willfully causes, right? And that's a reflection that a passenger in a reckless getaway car, the default should not be that the passenger gets this 3C 1.2 enhancement. There should be some sort of behavior by the passenger which calls for this 3C 1.2, because at its base, this is an obstruction enhancement. This is when arrest is imminent, when law enforcement officers are on our tail, what behavior is being displayed. And in this case, with Mr. Rivers, we do not have that. The district court relied on the fact that Mr. Rivers initiated the carjacking, and that after there was this very severe crash, Mr. Rivers did not just stay in the vehicle, he got out and fled on foot.
But it was more than just fleeing on foot, wasn't it? That he took them across a highway, down a very steep, dangerous embankment. In fact, one of the officers got hurt on the embankment, into a creek. Why isn't that sufficient to qualify for the enhancement?
Because I don't think that the flight on foot by itself constitutes the sort of reckless endangerment that this sentencing enhancement is contemplating, right? The drive, the chase, tremendously dangerous. We've conceded that in our briefs. But the flight on foot, you've got a different power dynamic. You don't have Mr. Rivers carrying any sort of gun when he's flying on foot. We're in a very different posture if he's carrying a gun while he's flying on foot. Here you have an armed officer chasing an unarmed individual who's flying on foot. And so you look at the Cespedes case out of the Third Circuit, Johnson case out of the 11th Circuit, Regg's case out of the 8th Circuit. Each one of those cases said that flight on foot alone, as a matter of law, is not sufficient to support this enhancement for a passenger.
But again, isn't this more than just flight on foot? You have to look at the totality of the circumstances and the conditions that he was fleeing in and where he forced the officers to go in order to chase him. And I think that's what, if you look at the district court's pretty detailed factual findings, the court was concerned about across a busy highway down this dangerous embankment, which is very different than just saying, well, he made them chase him on foot, and that's it.
I've seen I've entered around rebuttal time, may
please.
I answer? I don't think that the district court was as focused on the flight on foot. I think it was more of the car chase that was tremendously dangerous. I think the flight on foot certainly played into his analysis, but it doesn't get you to an active or direct participation in the flight from the officers in the car. Thank you.
Okay, thank you. Mr. Simpson? Good morning.
Good morning, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. I'll address the defendant's challenges in the same order in which the Court has just heard them. I actually did not hear counsel for Mr. Tucker concede that the in relation to element of 924C would be met here under the Court's current law, which is reflected in the jury.
And Mr. Simpson, if we decided this case the way that, I mean, put aside the standard, we may have some cleanup to do on the standard of review, okay, whether it's plain error or de novo, but I suspect you don't care all that much in relation to this case, okay, because even if it's de novo, I think your position is the potential to facilitate is enough. And I think every circuit has held that. So my question is, wouldn't we be creating a circuit split and going against all the existing law if we held that in relation to does not include a potential to facilitate?
Yes, I think you would. And I think you would, in fact, be going against Supreme Court precedent.
Yeah.
In the Smith case, the court clearly includes that potential for facilitating language. And that, again, is reflected in this court's case law and in the court's standard pattern jury instruction. Now, I think when we talk about the standard of review, we need to make clear what we're talking about the standard for. To the extent they're saying the evidence was insufficient to convict him on that charge under the court's current law, reflected in the pattern jury instruction, they have a very, very difficult standard here. This court has said that standard is almost insurmountable. You know, the question isn't whether you or
But
I.
that's preserved. I think the bigger challenge is, what are we reviewing de novo and what are we reviewing for plain error? Because Mr. Tucker's argument is partially sufficiency of the evidence. It wasn't sufficient to convict him on this count. And then part of it is, it wasn't sufficient because the law is wrong.
But, Your Honor, I think we first need to start with that first question. I think they apparently are, as far as I can read their briefs, I think they are actually saying, even under the current law, the evidence is insufficient. And on that,
I think they're saying that too. I'm more focused on what's the standard of review for the second piece of that. They're arguing it's de novo because they raised a general Rule 29 motion at the end, and that preserves all factual challenges as well as legal challenges
I think
under a sufficiency.
It is very complicated, Your Honor. I agree with that. Part of the reason it's complicated is that the court's current law, which they're challenging, is reflected in the pattern jury instruction to which they agreed. So I think that should inform how the court sees the standard of review on that legal challenge, so to speak. Obviously,
But
our
does
position.
that mean that we say, you know, I think this is an interesting question. I understand the defendant's argument. It's not frivolous, okay? But, you know, to say that we make a sufficiency challenge, therefore we preserve everything. And when you take the facts and you apply them, forget the existing law, okay? I understand that's their argument. They have a very, very difficult challenge to say, if we apply the facts to the existing law, Tucker wins. It's a very, very hard argument. But I think the argument is, if we apply the existing facts to what the law should be, Tucker wins. I think that's a hard argument too. But even if they say we apply the law to what the law should be, and then us, when in determining what the law is or what the law should be, do we review that for plain error because they didn't object to what the law is in the district court? So, in other words, we never get to the question of what the law should be because we just apply what the law is. And we say it would be plain error, you know, under plain error, maybe our law is wrong, okay? But that's not an obvious error for the district court to correct. In other words, the district court couldn't correct anything. The district court just had to apply our law, and therefore it's not plain error. They lose under plain error review. I think they would agree with that.
I hope they would agree with that, Your Honor. I'm not even sure I've heard that. We think it should be waiver. That's our first position. Our second position is that it should be plain error, and as the court said, they would lose under that. It would go against not only this court's law, but also Supreme Court law. If I could just kind of, I don't think we've actually.
I want to, actually, before you do that, I just want to follow up on the standard of review. How do you respond to Mr. Tucker's argument about Castillo and some of our other case law that has loose language, that a general Rule 29 motion for acquittal preserves all arguments regarding factual sufficiency, including legal arguments that might be bound up there?
Your Honor, I've dealt with that law before. Frankly, it doesn't seem to make sense. There are statements, as the court has alluded to, there are statements in the case law to the effect that if you do say in that motion what you're challenging, then you're preserving that, but you're waiving everything else. That doesn't make sense. If you preserve that, you waive everything else. But then if you don't specify what you're preserving, then you preserve everything.
So is your response that our law is not correct, that it's just loose language in our law, or that it doesn't make sense, but it's our law, so we have to apply it or change it? What's your response?
I think I know that it would be difficult for this panel to change the law because it seems to be the law of the circuit. I think that our bottom line would be, even under plain review, and my understanding is that the court would be applying plain review even under that existing law and preserving
Well, that's
issues.
not, that's, the argument is that we should apply de novo, because it was preserved with this general Rule 29 motion, even the legal issue.
And all of this gets to the next point, which is, as the court has said, it's very messy. Since Mr. Tucker is seeking to overturn existing circuit law, and again, we believe existing Supreme Court law, which I suppose they hope to get to that point at some point, they have the compelling reason. So even if it's de novo review in a technical standard of review sense, they have to satisfy a compelling reason to overrule current circuit law. So maybe the answer is it ultimately doesn't matter what the initial appellate standard of review is, since they have to satisfy that compelling reason standard. I could just kind of talk a little bit about what the evidence is, and I believe this goes a little bit to Judge Kirsch's question earlier. We believe, and I believe this was a question also to counsel for Mr. Tucker, we believe that the in relation to element was satisfied, even if we take out the potential for facilitating language. And the reasons for that, let me just a few sentences on the evidence, what the evidence showed. The Cobra was on the ground outside the BMW after Mr. Tucker jumped out of the car, the driver's side door, and before Mr. Rivers jumped out through the same door. The front passenger door was pinned shut, so Mr. Rivers came out. But you can see in the video, that video is Government Exhibit 22C. You can see that the Cobra is on the ground, this large black pistol is on the ground, right after Mr. Tucker exits and before Mr. Rivers exits. Also, Mr. Tucker's DNA was found on the 9mm Cobra. Only 2 men in the car. We know that Mr. Rivers had 2 guns. One of them he had been firing outside the window. That was the Taurus. The other one was also with the Taurus under his passenger seat after the accident. So the reasonable inference, and that's what we're talking about here, what the jury can find, the reasonable inference was that Mr. Tucker had the Cobra with him in the car, either on his lap or on his waistband, and he dropped it when he got out of the car to run away. I believe counsel for Tucker has admitted that if, and I believe it was in response to a question from the court, if a defendant has a gun on the holster, then it's certainly in relation to. But here he had the gun somewhere on him, somewhere very close, so close that he dropped it upon exiting the car. So he certainly carried the Cobra, at least for protection and a sense of security. He put himself in a very dangerous situation, and he brought the tool that he needed for that situation. Now, again, so to address the legal challenge here, I would emphasize that not only are we talking about the court's case law, the Supreme Court's case law, but also that is reflected in the pattern jury instruction. He seeks to take out this phrase, have the potential of facilitating, and the defendant's first problem with that, we believe, is that even if we were to take out that phrase, this would still be an appropriate, a proper conviction for carrying a pistol in relation to the carjacking. The 9mm certainly facilitated Tucker's participation in the carjacking by providing protection and a sense of security. And in fact, we mentioned this in our brief, it seems to me that the fact that they include this legal challenge in their brief and here at oral argument reflects the fact that they apparently recognize that they satisfy that they don't have a good position on the facts here. And under the law, We've already talked about this. This challenge is a very tall order, both procedurally and substantively. Procedurally, because we have this potential problem with waiver or whatever we want to call it, and even under plain error review, it would fail. It reflects the statements of this court and the Supreme Court. The actual language of the jury instruction comes from the Supreme Court's decision in Smith, where the court says a gun must at least facilitate or have the potential for facilitating the underlying offense. In fact, elsewhere in the Smith decision, this is on page 238, the court says that in the quote-unquote ordinary case under section 924C, in the ordinary case, the court says the ordinary case involves the gun providing a means of protection or intimidation. Certainly here, that at least that is what happened. So that's the law, and only the Supreme Court can change it. A few words on this, on the Dubin decision on which they rely. That's obviously on an entirely different statute. The Supreme Court said, besides the other things that have already been said this morning about Dubin, the Supreme Court itself said in Dubin that the term "in relation to" is, quote, particularly sensitive to context. I think this case bears that out. So moving on to the appeal by Mr. Rivers, if I could, he of course was the passenger. I think it's striking, not surprising, that he does not challenge his 924C conviction, since the witnesses saw him firing his .40 caliber Taurus while leaning out the window of the car during the initial stage of the getaway. The application notes to 3C1.2 say that the defendant is responsible for his own conduct and for any conduct that he aided or abetted, induced, or procured, and there are a few other verbs in there as well. But I think those.
Do you think the district court was relying on the aiding and abetting conduct as opposed to his own active participation in it?
I think that very much the court was relying on both of them. And what the case law shows is that where a defendant is engaged in activity like this, and this is partly the Byrd decision from the Sixth Circuit that we cite in our brief, where the court is engaged in something like this and the defendant is demonstrating, which is not surprising here, is demonstrating a great desire and motivation to get away. We can infer from that that he's aiding, abetting, inducing, or procuring the driver's own activities. As the district court pointed out, Mr. Rivers started this carjacking. He's the one who started the whole thing. He's the one then who ordered the victim out of the car at gunpoint. He's the one. Mr. Rivers was the one who yelled at Mr. Tucker to unlock the car so they could get in and get away. Rivers was the one who fired at the three bystanders as they left the scene. Now, I'm not saying that use of the gun itself is part of the dangerous enhancement here. What I'm saying is that Mr. Rivers' activity in shooting at the bystanders was presumably to ensure their escape, and also that itself increased his own personal interest in getting away quickly. And Rivers then stayed in the car as they took that 12-minute joyride that would normally take 20 minutes, speeding and blowing through a stop sign and weaving in and out of traffic. So, Your Honors, we encourage the court to affirm here. One point on the remand in light of the amendment to the guideline on status points, that should be a limited remand, only limited to what would be available under a motion under 3582C2.
Thank you, Mr. Simpson.
Thank you, Your Honors.
We'll give you your 2 minutes.
Thank you, Your Honor. I'll try and get through 2 points, one on the standard review and one on the state of the law. In regards to the standard of review, on pages 15 to 16 of the reply brief, I quote United States v. Mays. Mays discusses this, and that is another basis for the fact that a directed verdict is reviewed de novo and everything's preserved. And the basis for that is
The Mays language definitely suggests that. What gives me pause is there's no citation behind the initial language. There are citations later on, but for the proposition that legal issues are caught up in there, there was no citation.
So the advisory committee notes, I believe, were a citation in there, and that they say that parties to a criminal case, unlike civil parties, have no general obligation to support the motion with specific reasons. And that's, and you know, we follow, or Tucker's
It's certainly
trial.
on sufficiency of the evidence and on evidentiary issues. I
Okay.
think the state of the law says that. It's the legal point that I'm caught up on, because it seems like you didn't object to the jury instructions at the trial, and it's a backdoor way to get de novo review of legal issues where the district court was not given an opportunity to address it in the first instance. And it's one thing to say that in a rehire situation where the law has changed during the interim, but something that was available to the defendant to raise, where the defendant didn't raise it before the district court, it just seems like a backdoor way that's not right.
I recognize that discomfort. I think maybe that's the best word for it. And to the government's point, and maybe what I'm inferring or hearing is that it should inform the standard of review. The government didn't offer any legal basis to that then requires the defendant to challenge the jury instructions as well. And so to the extent,
What's the incentive then to ever get something cured on the front end?
yeah.
That you'd wait and just roll the dice, and if you're convicted, then bring it up for the first time on appeal.
I'd say that those are way worse odds than flagging it below. I mean, if you or I were trying the case, we would bring that up. His counsel did not. And you'd want the jury to be aware of that, particularly when in talking with Mr. Tucker. The whole reason why he went to trial was the 924C charge.
Right.
This was not.
That's it.
Right. It was the 924C charge. And if I could make just one quick
Sure,
point
go ahead.
on the law, Judge Kirsch, to your point about a circuit split, I believe that it's not the state of the potential of facilitating. It's not the legal standard in the Ninth. I have not canvassed all the circuits. I don't think it's the case, though, in every circuit. I'd be happy to supplement briefing on that issue if you'd like. And then the final point I make is that the government still is not contending with the fact that the Solicitor General represented to the United States that Smith adopts a facilitating standard. And the fact that the government didn't address Dubin in its response brief, and still today is not addressing what the Solicitor General said, I think is quite problematic.
Okay. Thank you.
Thank you.
Mr. Dracosin? We'll give you your full minute as well.
Thank you. Just two quick points. First, to Your Honor's questions about flight on foot. When you were asking me, I direct you to our briefing on the Reyes Segura case out of the Ninth Circuit, Gold out of the Fifth Circuit, Mucus out of the out of the Sixth Circuit. It says mere flight, even if it results in arm pursuit, does not justify the enhancement. It's a categorically different degree of dangerousness flying on foot than a car chase. And the second thing I would add is that the government brought up a lot of offense conduct. The PSR specifically says it's not basing its recommendation for a 3C 1.2 on the gun behavior that Mr. Rivers undertook. That was terrible conduct, right? He's already getting punished for that. And if you want to talk about, severity of the conduct does not inform the applicability of this enhancement, I'd ask you to look at the Regs case out of the Eighth Circuit. There you had a defendant who shot the clerk and pistol whipped the clerk, and yet the Eighth Circuit said this enhancement doesn't apply because that did not inform the defendant's behavior during flight. This case should be remanded for resentencing. Thank you.
Thank you, Mr. Dracosin, and I understand you were appointed to
Yes.
represent Mr. Rivers. Thank you very much for taking on the appointment and for your strong advocacy and written work on behalf of your client.
Thank you very much.
Thanks to all counsel in the case. The case will be taken under advisement. The next case for argument this morning is appeal number 23-3285, Ray versus Tabritz, the appeal of Blue Cross and Blue Shield Association. Good morning.
Good morning, Your Honors. May it please the Court. Adam Feinberg on behalf of the appellant, Blue Cross and Blue Shield Association, which I'll probably refer to as Blue Cross. This appeal involves two main removal jurisdiction issues where the removing party, Blue Cross, removed on two separate grounds. one, under the Federal Officer Removal Statute, 28 U.S.C. 1442, and second, under the normal removal statute, section 1441, on the basis of federal question jurisdiction.
Mr. Feinberg, it seems odd that the district court, who's extremely thorough, didn't address the federal officer removal statute. Do you have any insight into why?
I do not, Your Honor, but I think that is one of the key issues here. It is a mystery to us. There's really no reason why the district court shouldn't have at least considered why the motion for adjudication shouldn't have stayed in the federal court. And I'll get to this later, but this has come up before where it's not clear, or maybe even a party removes the entire case mistakenly, improperly, under the federal officer removal statute, and the courts generally will keep the federal officer removal portion, or the quote proceeding, under the language of 1442 D1, and remand the rest of the case.
Has any circuit held you cannot do that?
No, Your Honor. And in fact, the Ninth Circuit in the Goncalves case, which we cite repeatedly, this exact scenario came up. So the removal notice removed the entire action, and this was a sole removal, or the sole basis of removal was federal officer removal. The removal notice said remove this action, not the lien proceedings, also a medical malpractice dispute with ongoing proceedings in the state court, because the plaintiff in the medical malpractice action was a minor, and the court needed to go through a whole fairness it's essentially a probate proceeding under California law in order to approve the settlement. That hadn't happened yet. Blue Cross, a different Blue Cross entity, but under the same exact plan, removed the action. That's what the removal notice says, and the Ninth Circuit in Goncalves repeatedly mentions that, the action. And Goncalves says, well, the action's not removable. And the Ninth Circuit addresses that point at page 1249 of its decision and says maybe Goncalves is right, that the entire action isn't removable. Although, interestingly, it does leave open the possibility that the entire action was removable, even under the federal officer removal statute. But in footnote 3, the court says it just doesn't matter, because it's plain that Blue Cross was removing on the basis of the lien proceeding, and it addressed whether or not that part of the case was properly removed, and held, of course, that it was.
Do you concede here that if the federal officer removal statute allows for removal of the motion for adjudication, that the medical malpractice part gets remanded?
Under the federal officer removal statute
Yes.
only?
Yes.
Absolutely. And to be honest, Blue Cross has no interest one way or another where that part of the case ends up. That's not our concern at all. And I'll come to the federal question.
Why isn't this an in rem proceeding? Why is this not an in rem proceeding that should go back to the state court?
Which piece are you talking about, Your
Well, the adjudication.
Honor?
The adjudication is really the only thing that's at issue, right?
Well, let me back up a second. In order for, I assume you're talking about the prior exclusive jurisdiction doctrine.
Yes.
So in order for that doctrine to apply, several things have to be the case. There have to be two simultaneous in rem proceedings. So the first question is what the piece that would be left in the state court an in rem proceeding, but then we also have to look at the piece that would be in federal court and say, is that an in rem proceeding? And only if
That's
those,
my question. Why isn't it?
both of those?
Right. No. The federal court. The piece that would be left in federal court. Why is that not just an in rem proceeding?
Because the adjudication of the lien proceeding nobody's brought an in rem type proceeding to say to the district court, I want you to seize these funds and order who should possess them. It's simply.
But isn't that the effect of your argument in the district court? It has nothing to do with seizure, right? It's not an enforcement action. I know that. It's a declaratory action. But doesn't it have the same effect?
Well, this is exactly the issue that the Goncalves court addressed, and the
The
answer
majority.
the majority, correct, yes. The answer to that is no, because if Blue Cross brought an action to enforce its lien, that might be an in rem
Do we have to
proceeding.
consider Illinois law, though? Which, again, the Goncalves case was not looking at Illinois law. Do we have to consider Illinois law in determining whether or not it's an in rem versus a personam issue, a matter?
On the piece that would be in federal court, no, I think that's a question of federal law. The piece that would remain in state.
Federal common law? What federal law would we use to determine whether it's an in rem proceeding in federal court?
Well, I think you would look at the federal common law as to what qualifies as an in rem proceeding. But there's a whole separate question here, and that is the piece that is in the state court, that would stay in the state court, is that also an in rem proceeding?
So
And-
I take it your point is that even if the motion for adjudication is an in rem proceeding, that's not sufficient to preclude the case from staying here. It has to be both pieces.
Exactly, and not only both
And
pieces.
what are you relying on for that?
So the piece that would stay in this, there are actually two separate reasons why the state court piece doesn't cause a prior
But why does it
exclusive
have to be
jurisdiction.
both, is the question. Not why isn't the med mal an on-rem, but why does it have to be both pieces in order to keep one piece here?
Why did
Why
both-
do both proceedings need to be in rem in order to keep one here?
I see. So that's just the basic law of the prior exclusive jurisdiction doctrine. So if you look at this court's decision in, I think it's Blackhawk Heating and Plumbing, it specifically talks about what the standard is and says two courts, one state and one federal. So the doctrine prohibits two courts, one state and one federal, from exercising power over the same piece of property and ordering its final distribution. Or this court in Hammer talked about the two suits, both of which are in rem or quasi in rem, and require the court to have possession or control of the same property, cannot proceed at the same time. That's what this court said in the Hammer decision. So the state court, the piece that we would say would belong in the state court under the federal officer removal statute, first of all, that whole proceeding was over before Blue Cross removed the case. The allocation of the settlement was made and completed, and in fact, the state court judge certified it as final and appealable before Blue Cross removed the action. And in addition to that, the proceeding itself, even if it was ongoing, is not in rem. Nobody was claiming, I mean, the money belongs to the Rays, other than Blue Cross's claim and the lawyer's claim. The person who opposed the state court motion was the non-settling defendant, Dr. Tabriz. He had no claim in this money. The court wasn't deciding who actually gets to keep the money. The court was just making a legal determination for purposes of the joint tortfeasor offset that applies under Illinois law. It's just deemed to be, okay, well, $1 million of the settlement goes to the injury claims, $250,000 goes to the husband's loss of consortium claims, because if there's a judgment against Dr. Tabriz, the state court will need to know that in order to compute the offset. But the court wasn't actually taking the money and saying who should actually keep the money. So that part is definitely not an in rem proceeding, and as I said, even if it was over. I want to just raise one other point about federal officer removal statute. Obviously, the Supreme Court and this court have repeatedly said that it's to be interpreted liberally, and I think that needs to be kept in mind in all of this. And I mentioned the Goncalves case, and there's a couple other district courts that we cited that said, well, at least the proceeding should stay in federal court, even if the rest of the case shouldn't. But here, of course, there's a whole other layer that wasn't present in Goncalves. We actually think and removed on the basis of federal question jurisdiction, and 1442 D1 explicitly says, well, when that happens, you're supposed to remove the whole case if there's another basis. And so the Ray's view here is sort of, well, if you're in the situation that Blue Cross was, you have this Hobson's choice of either removing just the lien proceeding or removing the whole case, but you can't really do both because it's not really possible to remove at the same time both all of the case and a piece of the case. Unless Your Honors have any other questions, I want to turn now to the federal question issue under which the entire case is removable. And I think the issue here is pretty clear. And just to be upfront, we readily concede that if we were here standing before you the day after Cruz was decided, we lose, end of story. But there are two important developments after Cruz that have to be considered when we analyze the two-part Boyle test about whether or not there's a uniquely federal interest and whether or not there's a conflict between that interest and the operation of state law. And one is the Neville's decision, which we admit is not a jurisdictional decision, but it does talk about the distinct federal interest, and it focuses in particular on the notion that these recoveries, which the court notes were in the magnitude of more than $100 million in 1 year, 10 years ago, so they are quite enormous, but because those are newer to the federal government,
How does Neville's really help you, though? Because we just reaffirmed that 1331, not the statute it here, doesn't confer jurisdiction.
Well, because of Cruz, are you talking about?
I don't know how Neville's helps you. It seems like it doesn't require anything different than Cruz.
Well, I agree with you. I don't think it requires it, but I think it's relevant because it does talk about the importance of the federal interest. In Cruz, the court said, well, the federal interest is uniformity in benefits, and the federal interest isn't really about reimbursement. But Neville's makes clear that there is a strong federal interest, the court says, in reimbursement because of these huge dollars that the United States Treasury recovers through actions like this that Blue Cross is undertaking.
Would that holding, though, be contrary to the Supreme Court's opinion in Empire Health Choice?
Absolutely not, Your Honor. And in fact, the 10th Circuit in Helfrich held that Empire supported the application of federal common law in a similar reimbursement dispute. And the district court here specifically said Empire doesn't foreclose our argument. But I want to address one other, much more important factor with respect to Cruz, and that is in 2015, well after Cruz, the federal government, the Office of Personnel Management, promulgated a regulation that expressly states Blue Cross's lien takes priority. And you simply cannot reconcile that regulation with the Illinois Common Fund Doctrine. And even if there was no conflict with state law and a federal interest before that regulation, there certainly is after, because the policy in that regulation simply cannot be squared with the state law here. Thank you.
Thank you. Mr. Ford? Good morning.
Good morning. Respected jurors, counsel. Your Honor, the Empire case and the Cruz case do not confer federal court jurisdiction. These are Supreme Court, there's really two Supreme Court rulings, Empire and the remand of the Cruz case to the Seventh Circuit to comply with Empire. Those cases are very close to being on point. One thing I want to point out in the Empire case is the court makes a specific notation that the insurance, the United States didn't choose to participate. They have a subrogation interest, in which case they can come in and participate in the lawsuit, but they chose not to. And that's the same thing here. They had a choice to participate, chose not to, and rather...
But that's not what usually happens. And I don't know that you want to encourage insurance companies with those interests to start coming into cases early. I'm not sure that's the point that should be taken away from that.
Thank you, Your Honor. You know, I understand, and really it goes to the equitable issues that the Illinois courts find. You know, each state has a different approach to the Common Fund Doctrine court, as we saw in Neville's wanted, and there's a distinction in Neville's. In Neville's, the Neville's case was a statute that says the United States doesn't get to recover anything, as opposed to here, where after 6 or 7 years of trial preparation, we finally get to a point 5 days away from trial. One of the defendants wants to get out. And I'm going to hand the United States a check. I'm not going to fight them. I just want to follow the Illinois Common Fund. For doing no work, I want to hand them a check. And instead, they removed not just the claim on reimbursement here, they removed the entire case to the federal court.
Can you shed any light on why the district court didn't address the federal officer removal?
That's what the defense says, but I disagree with that interpretation. Your Honor, if we look at, and I'm going to pull that opinion out because I don't want to misquote it. What happened in the case in the briefing is they removed the entire case based on federal officer jurisdiction. And we, in our response, said, you cannot do that. The Seventh Circuit case of Hammer says you can only, you can't remove, it's not an independent cause to remove the entire case. And Blue Cross in their reply said, we agree with you, plaintiff. We agree that we don't have that right. And the court recognized that if you, I think it's on the last page, Your Honor, of the opinion. It says that in its opposition to remand, Blue Cross Blue Shield Association agreed with the Rays that under 28 U.S.C. 1442 D1, only the motion for adjudication and not the entire case could be removed to federal court unless there's a separate basis of removal. There, Blue Cross Blue Shield hung its hat on federal court jurisdiction. So the
That
district...
sounds like, though, the district court was saying that they argued federal question jurisdiction, but they didn't argue federal officer.
What the court is
But
saying...
you can't waive jurisdiction.
I understand that, Your Honor. But we have to recall, we have to go back to what actually happened here. They removed the entire case.
Right.
Okay? And you can't remove the entire case under federal officer jurisdiction standing alone.
I'm with you.
Okay. In this case, respectfully, Your Honor, we have 2 Supreme Court cases and a Seventh Circuit case directly on point. There was never an issue, it really is never an issue, about federal court jurisdiction. In the Empire case, the Supreme Court invited Congress to, if they want to make this jurisdictional, we invite you to make that, to make a public act in it. 20 years have passed. Congress never acted on that issue. There has
So
never...
are you saying that the federal officer removal doesn't exist or is not a basis
No,
for
I'm not
federal
saying-
jurisdiction? I'm with you like halfway there, but then I lose you on the argument why the district court should not hold on to the determination of whether the federal officer, federal officer doctrine under federal officer removal applies.
The issue, well, in other words, if hypothetically, Your Honor, what they did was removed singularly that issue, then that might be a different case.
Why though?
But-
I mean, because let's say they remove the whole case, why can the district court just not remand the portion of the case that should not be in federal court, but required to maintain the portion of the case that should be in federal court?
Well, Your Honor, I've been dancing around courtrooms in this state for 44 years, so I wouldn't ever say that a judge or an appellate court couldn't do something. But I think...
Well, there's a lot we can't do.
Yeah. But Your Honor, respectfully, that would entail sort of an equitable remedy if you're going to...
Counsel, the Supreme Court's reminded us that we can always look for fees if something's removed, and that's not appropriate. But here, there are 2 questions. Are we removing under federal officer removal the motion for adjudication, and are we removing the entire case under federal question? Even if you're right that the federal question just has no merit. Not sure I'd go that far, but just assume you're right, okay?
Right, yes, sir.
There's the second question about what do you do with the motion for adjudication. And in the briefing below, Blue Cross mentions the motion for adjudication. On the order that you just read from, which I believe is the one from the motion for reconsideration,
That's correct, Your Honor.
very thorough analysis under the Boyle factors. In that last paragraph, it mentions the motion for adjudication. But the conclusion isn't, so we're going to keep the motion for adjudication, the rest of it goes back. Maybe even, hey, Blue Cross, we're going to have some briefing on whether you owe fees for trying to bring the whole case up here, but we're also going to address the motion for adjudication. Why wouldn't that be appropriate?
Okay. Very good. So what I then want to address, in Your Honor, is the next part of my argument, is as to whether or not there's an appropriate federal officer jurisdiction here. And
Well, I think before you get that, we're trying to understand, the district court said, essentially, you can't remove all of the case under federal officer, but there was never an analysis of why can't you just remove the motion for adjudication, which is what the issue on appeal is. And it just seems strange that,
Well,
given how
that-
thorough the court is, that wasn't addressed.
that is an issue on appeal, Your Honor. And that's why, as Your Honor recalls from my brief, I talked about judicial admissions and the concept of,
I don't, if your argument is, which I think part of it may be that, well, they tried to remove everything, so we don't get to address the motion for adjudication only. I don't think that's a winner, because their notice of removal specifically refers to the motion for adjudication multiple times as what they're trying to remove.
they removed, Your Honor, the entire case. And in their notice of removal, they didn't note that they were removing only the motion for adjudication.
Do you concede under federal officer removal that they could have just removed the motion for adjudication?
I mean, they can always remove it, Your Honor. Whether it's an appropriate removal or not is another issue.
That's my question.
Yeah, I mean, certainly.
Do you concede that we would have jurisdiction over the motion for adjudication under the federal officer removal statute?
Actually, I don't, Your Honor.
Why not?
Because it is-
Focus your argument on whether or not we have jurisdiction on just the motion for adjudication.
Okay. Respectfully, Your Honor, the issue that was before the district court was whether it was appropriate to remove the entire case.
If you
Because
could please
that's what was
focus
done here.
if you could please focus your argument
Yes.
on the motion for adjudication and whether or not we have
Yes.
jurisdiction under the federal officer removal statute for the motion for adjudication only.
You know, the Watson case, Supreme Court case in Watson, takes a long time in discussing really what the Federal Officer Removal Act is for. It talks about, it really goes through a history of why it came about. And the idea was that we don't want the states interfering with federal government enforcement of laws. And here, we don't have any interference.
Are you saying it doesn't apply, that the statute doesn't apply, and therefore it's not a basis for removal?
I'm sorry, Aaron, I don't understand.
Well, I'm not sure where you're going with this. I mean, in response to Judge St. Eve's, I don't think you're answering Judge St. Eve's question,
sorry, I
which
thought it was.
I'm very interested in the answer to that question too.
Okay, I don't think that there was ever a conflict between the Illinois Common Law Fund.
So what does that mean, though, as to jurisdiction?
I think in order to have jurisdiction, to properly remove under the, if hypothetically what they did was removed, just the motion for adjudication. then the question is, would I fight it? At that point, in that hypothetical case, I would, because it makes the assumption that the state court can't handle.
Well, that's not a requirement to remove under the statute. There's the 4 elements that have been identified. Nothing says the state court can't handle it.
I mean, state courts are entirely competent to handle Title VII cases. I can guarantee you they can handle employment cases, but they're brought in federal court because that's what the law allows. And I mean, state judges are perfectly equipped, no doubt in my mind, to apply the federal removal statute. Okay, they can apply the statute. There's no doubt about that. But the law says federal courts have jurisdiction. And the law also says when federal courts have jurisdiction, they must exercise that jurisdiction if the case is in federal court. We can't remand stuff just because we don't like it. We would remand a lot.
I understand, Your Honor. There's a couple of issues that arise here. One is the Supreme Court has many years said we have to recognize the state's rights. And then the question is, do you want to expand jurisdiction?
Well, this particular statute is to be liberally construed. And our case law makes clear there are 4 elements you have to meet in order to do that. And competency of the state court is not one of them.
Yes, give me a second. I've got a tag, Your Honor, because I anticipated that.
We laid them out in Betzner versus Boeing and many other cases.
And so the question is whether or not, and I think that's what I was trying to get at in Watson. Watson talks about the people protected are those who are enforcing the law. There is really no enforcement of the law here.
Which of the 4 elements that we've identified are relevant to this removal are you arguing can't be met?
It's actually 1 and 2. Is a person within the meaning of the statute and is acting under the United States, its agencies, or its officers. And I think that gets back to my point originally in Empire. And maybe I didn't make it clear enough.
But Empire deals with the federal common law issue, not the federal officer removal.
The one comment in Empire that I find important in this regard is Empire talks about the United States had notice of this action and chose not to participate. They chose not to act. In the federal officer removal statute, the removing party must show it's a person within the meaning of the statute and is acting under the United States, its agency, or its officers. Just as in Empire, in this case, the United States had knowledge of this action and chose not to act. They could have participated at any time. I would have loved to have shared the expenses in this case, and maybe some of the legal work. They chose not to act. They decided to rely on my work, my money, and expenses. And so I don't think there was a federal officer acting in this case.
Okay. Thank you, Mr. Ford. Mr.
Thank you.
Feinberg?
Thank you, Your Honors. Just a couple points briefly. I think the court is well aware of what the test is for federal officer removal, so I won't go into that. The first factor, person, I think it's quite clear corporations count, and many courts have said that, including Goncalves and Jacks and others. And the acting under 2, thoroughly addressed in Jacks and other cases that we cite, so there's really no possible argument there. Mr. Ford mentioned the Watson case, which has really no bearing on this whatsoever. Watson involved a tobacco company that was a regulated entity, as many people in the public are, or companies in the public are. It had nothing to do with somebody who, like Blue Cross, contracts with the federal government to operate a federal treasury account and administer a federal benefits program. And Mr. Ford also said that there's no conflict with the Illinois Common Fund Doctrine, and Judge St. Eve, you mentioned that that's not a factor, which is right. But I want to point out that in any event, because this is relevant to the federal common law issue, there is a conflict. There's an enormous conflict that started in 2015 because the Common Fund Doctrine says a lawyer has a right to the settlement fund. And the federal regulation that OPM promulgated says any subrogation recovery on the part of a FEHB carrier shall be effectuated against the recovery first, before the rights of any other parties are effectuated. And the only other point I want to make, Your Honors, is why the district court didn't address federal officer removal. And I suspect the reason is because the plaintiffs really didn't raise it. They never contested it. Their motion for reconsideration doesn't mention it at all, and it's barely mentioned in their motion to remand.
Thank you, Mr.
Thank you, Your
Feinberg. Thanks to both counsel. The court will take the case under advisement. The next case up this morning for oral argument is 23-3286, Lee versus Franisca Cabby.
Good morning, Your Honors.
Good morning. Just 1 second. I want to make sure we have everybody.
Yes.
Here we go. Good morning, Ms. Akins and Ms. Cantrell. Can you hear me okay?
Yes, Your Honor, I can hear you.
All right.
Yes, good morning.
Ms. Akins, whenever you are ready.
Thank you, Your Honor, and may it please the court. My name is Carla Akins on behalf of the appellant who is the plaintiff in this matter, Ms. Lee. I am requesting that the court basically reinstate the case because there were numerous questions of fact at the very least. I think the evidence was overwhelming with respect to the fact that the company did not seek to accommodate Ms. Lee, that she worked there without issue for basically 5 years.
How could they? How could they accommodate her? You never explained that. At least I don't see any explanation of how they could have accommodated her anywhere in the district court or in our court. How could they have accommodated her?
Well, respectfully, the interactive process is the job of the employer. So she was asking them she sent them her notes, they met with her, and then they demoted her. So they did understand at least that because they put her in a job that she was able to do for a temporary period of time, which involved lab work.
So they could have accommodated her by changing her job? Is that the argument?
They did change her job. No, yes, that's one of the
arguments. Okay.
Yes.
Does the law require that as a reasonable accommodation? If you can't do this job, we're required to give you a different job as a reasonable accommodation?
If they can, unless it presents some type of hardship to and I don't want to miscite the language, but unless it presents some type of hardship to the company, in some way that they could say that they couldn't accommodate her, then fine. But with respect to, I think Mr. Davis, there's really not anywhere else you need to look in the record other than a few pages in Mr. Davis's transcript and a few pages in plaintiff's transcript. Davis.
I'm just curious if we take that to its logical conclusion. If you're a truck driver and a truck driver says, I can no longer do my job as a truck driver because I can't use my right foot. Let's say I can't drive a truck anymore. But there's this other position that's open, and it's an office position. And as a reasonable accommodation, you must put me in the office because I can do that job and the job is open and that's a reasonable request. And your argument is that the law requires the truck driver now to have a desk job?
If it's a reasonable accommodation, then I guess I'd state that it would. In this case, we're talking about scientist to scientist in job duties she was already doing. So I just want to be very clear about that. That's why we make such a big deal about the distinction between lab work and bench work, because the promotion, she requested the promotion. So the defendant received the benefit of her services until she finished the project, pretty much right up until the end, for 3 years. And then at that point, she asked for a promotion. Somebody else was promoted over her who had less experience than her. They had no experience in the job at all. And she had over 15 years by the time she even started the job at the age of 51. So at the time she was there, she was already doing this type of lab work. I want to be very clear about that. When she asked for the promotion, it's basically to do peer reviews. She did ask to be able to, this was page, sorry, cited correctly, in a 184 to 190, she talks about that. So she's talking about asking them about other things that she could do, asking them to train her on doing the peer reviews, in which they just her manager, Mr. Weber, just flatly denied her that ability.
Counsel,
and so Yes.
You're talking about a promotion, and that promotion was discussed, but then there were some performance issues, and she never got the promotion, correct?
We dispute that there were any performance issues. So they actually gave her a bonus. This is all within a month. And so that's the issue, the timing, which under Loudermilk is a question of fact. So at the point that she's asked for an accommodation, they're going through these things that she might be able to do. Then all of a sudden now they say that there's a problem. And so there's a question of fact there because they say, we had a problem with her reports. And then Mr. Land, who's the same one who said he wasn't promoting her, is the one who says, well, everybody has modifications to the report. Doesn't mean that there's a problem. And if there was such a problem, then why would you give her a performance bonus at the same time? Again, in the same month, you give her a performance bonus based on the work she's been doing for the last 3 years. It doesn't make any sense. And it's literally not until she gets demoted, as she called it, and that's page range I'm talking about, that's where she discusses this. She calls it a demotion.
That bonus was given before they reviewed the report, and the report was deemed insufficient and substantial changes were made to it before it was submitted. So what impact should that have?
I'm sorry. Go ahead. I'm sorry. I couldn't hear.
What impact should that have on the analysis?
I think if we're getting into the facts, there might be saying that, but I don't believe that that's how this actually occurred.
But you
This
don't
is the
dispute
defendant's-
that, you don't dispute, or I certainly didn't see it in the documents in the briefing, that the report that was submitted to the FDA had to be substantially revised from what she initially turned in.
That's a standard thing that happens. That didn't mean she did something wrong, and that's where the dispute comes in because the employer is trying to say, and that's what
Where's the evidence that that's a standard procedure?
Mr. Land's testimony, that's in our statement of facts. I want to make sure I cite it correctly. He states, that's when they talked about her deviations, and they said defendant says that Mr. Land said this, but if you actually read what he said that most modifications to reports are normal. That's from his actual testimony. He does what they've said he said and what he actually said, which happened a few times, were not the same thing. And so that's where the dispute comes in, because he's saying that everyone has to do modifications, that's normal. So that's, again, if that's what the issue is, and I think that comes down to a question of fact that they've created, because he's saying that that's what happened. That doesn't mean, just because there were modifications doesn't mean she didn't do her job correctly. And there hasn't been anything that anybody's shown in writing to say that these are the problems that you had. I mean, these are people, the same people who are saying this are the same people who did these actions. So I would think that we would at least, under a cat's paw theory, say that it's the same. I mean, it's the same actors. There's no separation there, and I haven't seen any evidence to the contrary to say otherwise. So, but they didn't fire her. They didn't actually demote her. They said what they called themselves doing was giving her a different job. And then the job didn't require the bench work. And the trial court made a determination with respect to bench work that that was an essential job function, which, again, under Seventh Circuit precedent, Brown versus Smith, that's a question of fact as to whether it was essential. Obviously, she was able to do certain job duties there, and they did have her doing them during the time she requested the accommodation. And then suddenly she couldn't work anymore, and she wasn't allowed to even do the job that she had been doing. So there's several parts to this. They still have to engage in the interactive process. Nobody did. There's Mr. Davis's testimony. I want to make sure I cite that correctly. On pages 21 to 23 of his deposition transcript, he says flatly, "We fired her because she couldn't do bench work, period." So there wasn't anything about you didn't do your reports correctly. You weren't handling your job. He said you could not do bench work. That's the reason. And he was very unequivocal about that. So at that point, if the determination of what essential function is a question of fact, and you're saying that that was an essential function and that's why you fired her, not for any of these other reasons about the FDA reports and all those other things, I think that's respectfully background noise, because I don't think they are not saying that that's the reason that she was terminated. They were pleased to keep her. If they want to say that's the reason they didn't promote her, that's a separate issue, but that doesn't mean that that's the reason she was terminated. Those are two separate things. And respectfully, we have a dispute with respect to whether or not she actually was not performing. They still used her work and she had other things that she had done. No one explained any of these things to her. She's hearing this now, from during these trial proceedings as to why they weren't giving her this promotion, what it was she did. She's telling them, and she had all of her ducks in a row, where she presented evidence to show that she had overperformed, that she had more experience than this person, and none of that was explained. They just didn't promote her. So again, these things are coming after the fact, and I think with respect to the timing there, that would at least raise a question of fact. I think that's why the Seventh Circuit has held that it is a question of fact, because an employer could come in here and say anything, but if they don't tell the employee that, then why would they be given the benefit of the doubt? The issue of pretext is a matter of fact, a question of fact as well. It's not in Loudermilk, they talk about the jury being able to determine the sufficiency of even an inference. That means if you present enough evidence to survive and say that there was pretext here, then the court has to consider that and allow it to proceed to a jury to determine if what you have submitted as pretext is actually enough to present a question, enough to rule the day for you in a trial. I don't think that it was for the trial court to get involved here, where in 5 pages of deposition transcripts between 2 major witnesses, the HR manager and my client, we were able to determine exactly that there was no accommodation offered and that she was terminated because of what they called her inability to perform the essential functions of her job, and no other reason.
Ms. Higgins, can I clarify something, please? Your
Sure.
briefing doesn't make any arguments with respect to the district court's ruling on your motion to reconsider the right to sue letter. So I assume you are not appealing anything with respect to the district court's ruling on the motion to reconsider. Is that fair?
So you mean to the extent that we included the right to sue letter in the reconsideration and not prior in the response to summary judgment?
Yes, the district court's ruling
Okay.
on the reconsideration only. You have not challenged that ruling in any way in your briefing. So I just want to clarify, you don't think you're appealing that.
Well, our first issue is that the matter of exhaustion it should have been settled because she had right to sue. So I'm not sure. I want to be clear that to the extent that if that's what you're
Challenge the
suggesting,
district court's
stating
initial ruling on that, but there's nothing challenging the district court's motion to reconsider when it would not consider the right to sue letters you submitted.
Okay. I mean, my argument here is that they should have considered them. It's not a jurisdictional matter. It's a matter of, that's an affirmative defense if they want to say it, but these documents existed. I don't think that we had to attach them to our pleading.
Jurisdictional is different than preserving issues for appeal. You just don't make any arguments about the district court not considering those letters.
Well, the only thing I can say is that I am arguing that the letters existed and should have been considered. If I did not specifically state, I don't think it was waived. I'm stating that she did exhaust with respect. The argument is that she did exhaust with respect to those letters, and that there was no failure to exhaust. I think the issue is of the existence of the condition, not that I had to attach right to sue letters in order to be able to say, like, did I have the right? Yes, we did, and the district court should have considered that. So I don't believe that was waived to the extent that that's what you're asking me, and I apologize if I wasn't clear on that.
Do you want to reserve the rest of your time for rebuttal?
Yes, I would. Thank you.
Thank you. Ms. Cantrell?
Good morning, Your Honors. May it please the court, my name is Stephanie Cantrell. I represent the defendant at the lead, Fresenius Cabby.
Ms. Cantrell, can you hold on 1 second, please, and stop the clock if you would? We can barely hear you. I don't know if it's on your end or our end. Just 1 second. Our tech gurus are seeing if they can figure it out.
Say something again. It sounded like you might have went up.
Good morning, Stephanie Cantrell for defendant at the lead.
Kind of the same.
Not better.
Can you turn up anything on your end? Because we have everything up to the max.
I switched my microphone. Is that any better?
Yes.
That's better. Thank you. Okay, we'll
Okay,
start the
you're
clock
welcome.
again and go ahead.
I apologize. We did test this earlier in the week, but you never know what happens the day of, I guess. So, Your Honor, I guess what I would like to first address for the court is this issue of interactive process. Counsel made several comments that there was no interactive process and that it was the defendant's burden. First of all, we reject the notion that it's solely the defendant's burden to engage in an interactive process. But moreover, there's ample evidence in the record that an interactive process was held with Ms. Lee from the moment that she indicated that she had disability issues that needed to be addressed. So we dispute that. We think there's ample evidence in the record. I'm happy to address those issues further. But I think the other important point that I'd like to note is that we believe that plaintiff is combining multiple issues in order to try to create a factual dispute. We heard counsel state earlier that there was no accommodation, but yet she was demoted and we called it an accommodation. Either she was accommodated by allowing her to do something outside her job, or she wasn't. And so I think to claim that that the accommodations that were given to her were actually a demotion is nothing more than an attempt to try to show a factual dispute when there really is none. The facts are actually pretty straightforward in this case. And I won't go into too much detail. I know you have them in the record, but from our perspective, yes, we acknowledge the fact that plaintiff was an experienced scientist. That's why she was hired. She worked very hard. She was acknowledged that she was working hard by giving her a bonus. And we saw that she was working diligently on the project commonly known as the vasopressin project. None of those facts are in dispute. She was a hard worker. She was an experienced scientist. The problem was when her report came out, it was insufficient. And suddenly the company realized that what they perceived to be hard work was not reflective in her report. And counsel makes some references to some deposition testimony in which one of the supervisors said, reports need to be revised all the time. That's true. But the main goals of submitting it for FDA approval were not met. And it wasn't minor revisions that needed to be made to the report. The entire report needed to be redone. So, and all of that doesn't really have anything to do, counsel is correct, none of that has anything to do with the reasons for her termination. It is the reason that she wasn't promoted. So that's why that was addressed in the factual section. That's our position. And again, it's well supported by the documents in the case. There are really 4 complaints that were alleged by the plaintiff. The national origin and age claims, as already Judge St. Aves, as you already pointed out, were dismissed for failure to exhaust. Disability and retaliation, the district court believed those also may have been, should have been dismissed for failure to exhaust as well, but we didn't make that argument. We were aware of the fact that there was an EEOC charge filed on those issues, so we argued that on the merits. And the court dismissed those on the merits. The issue throughout the lower court's opinion was consistent for all 4 of her claims: national origin, age, disability, and retaliation. In each case, whether it was for failure to exhaust or whether it was dismissed on the merits, the court found that there was no factual evidence in the record that could lead to a denial of a summary judgment motion. Plaintiff has a number of arguments, suppositions, beliefs, theories, conclusions. There's no evidence in the record. And the district court was very clear about that in both their initial order granting summary judgment and their denial of plaintiff's motion for reconsideration. We believe strongly that the evidence that we put into the record supports the fact that, number 1, Ms. Lee was accommodated by the defendant for over 7 months. She brought her restrictions to the company in August of 2019. She was immediately referred to as employee assistance. She was referred to employee benefits coordinator. She was given time off under FMLA. She was given the ability to apply for short-term disability. She was given accommodations for her lifting restrictions. She said she couldn't do bench work, so no bench work was allowed. To now call those demotions is disingenuous. Those were accommodations, and she was accommodated for her restrictions for over 7 months. The company worked with her to help her apply for short-term disability. Initially, she didn't provide the necessary medical records. They worked with her again in September of 2019. Finally, she was approved for short-term disability in November of 2019. She remained on short-term disability until March. When her short-term disability expired in March of 2020, the company notified her and said, "Let us know of your standing. Are you able to return to your position as a senior scientist who works in the lab?" She was not. But she said she had another doctor's appointment coming up. So they extended her leave. They protected her job for another month until April of 2020. Again, she was unable to perform the essential functions of her job. And that's what's key here. It's not a matter, we're not trying to parse facts about lab work versus bench work. As a senior scientist at Fresenius Kabi, scientists work in the lab. They sit at a bench and they perform experiments. That was her job. She was given an opportunity to try to do other work. She was trained in January of 2020 on the peer review work, and it was not successful. There was testimony provided that the work that she did as a peer review expert was not sufficient, wasn't working. It wasn't something that she was good at. She's a good scientist, no question, but she was not able to perform her job. When she wasn't able to return in April, the company extended her leave again and gave her until May to try to return to her job. As of May, she was still unable to perform the essential functions of her job, which was to perform cell-based assay experiments.
How do you respond to her argument that whether or not working in the lab was an essential part of the job is a question of fact and not something that can be determined on this record as a matter of law?
In the job description, Your Honor, it quite clearly says that lab bench work is an essential function of the job. There was also testimony to support that by two of defendant's witnesses. I do think that lab/bench is sort of used interchangeably, and not all scientists in all professions have to work in a lab. There are plenty of scientist positions where the scientists never go into a lab. But at Fresenius Kabi, that was an essential requirement of the job, and it is outlined in the job description. So again, we believe there's evidence in the record to show that A, she was accommodated, B, there was a reason that she was not promoted, and that was the failure of the vasopressin project, C, that she was accommodated for over 7 months, and her termination, counsel is correct in the fact that her termination was not because of her failure of the vasopressin project. Never stated that it was. That was the reason she was not promoted. The reason for her termination was that she was unable to perform the essential functions of her job. And this court has held that an employee who is unable to perform their work for over a multi-month period of time is no longer given the protections under the ADA. Multi-month, is that 5 months? Is that 7 months? I don't know. But time and again, the company worked with her, extended her leave, and granted her additional time to be able to return to her position. My understanding is that as of today, she still cannot perform bench work. And we're now 4 years later from the date of her initial injury. We don't believe that there's any evidence that there was a failure to accommodate or that she was discriminated against in any way because of her disability, and we believe the record supports that. If I may, I'd like to just speak briefly with respect to the claims of national origin and age discrimination. As previously alluded to, the district court dismissed those cases for failure to exhaust. We did, however, address those in our response brief to the court in the interest of a de novo review. So with respect to national origin claims, the company is diverse. It has a diverse workforce. There's no evidence that Ms. Lee, being of Chinese descent, had any bearing on her inability to complete the vasopressin project successfully, nor did it have any bearing on her ultimate termination in May of 2020. She, moreover, did not list any comparator employees that we believe were similarly situated to her in order to prove a prima facie case of national origin discrimination. She refers repeatedly to a woman named Ms. Raya. Ms. Raya is not similarly situated. She was a principal scientist, not a senior scientist. She had a position that was higher than the plaintiff. She did not have to work in the lab as a principal scientist. And so any comparisons to her, we believe, are unfounded. We don't believe that there's any evidence, if the court would review the national origin claims, regardless of the failure to exhaust, that there was any kind of discrimination as to Ms. Lee based on her national origin. Those similar arguments go to her claims of age discrimination. However, as we've explained to the court in our briefing, age discrimination has a higher standard under Gross, where Ms. Lee must show that age was the but-for cause of her termination, and had she not been over the age of 40, she would not have lost her job. That flies in direct conflict to her claims of national origin discrimination and disability discrimination. And again, the company has been clear in the record that she was terminated because she could not return to the essential functions of her job. Her age, again, had no bearing on this case. Moreover, we do believe that there was a failure to exhaust on both of those claims, and specifically with respect to the age claim, we don't believe that's properly before this honorable court. It was not a part of the motion to consider, and therefore her claims on appeal have not been told, and we don't believe that that's a proper claim before this venue at this point. So for all of those reasons, we believe that the evidence in the record was properly reviewed by the district court. It supports defendants' claims that there was no discrimination or retaliation. I'm sorry, I guess I didn't address retaliation. I'll just real briefly mention it. We were aware that Ms. Lee filed an EEOC charge in November of 2019 with respect to disability. That's part of the reason that we didn't argue failure to exhaust at the district court level. We never did see a right to sue from the EEOC, and we don't believe plaintiff received it until 2 years later, sometime in 2021. However, we were aware that a charge had been filed. Ms. Lee was not terminated from her employment until 5 months later, from November until May. There's absolutely no causal connection between her EEOC charge and her adverse action. Yes, we admit there was a protected activity in November of 2019. We admit there was an adverse action in May of 2020. The problem with Ms. Lee's argument is there's no connection between the two. Instead, she was accommodated. She was granted multiple extensions of her leave, and the company worked with her repeatedly to try to find work that she could do that would meet her accommodations, which were fairly restrictive, and prohibited her from doing her job. So for that reason, we also believe that the retaliation claims fail, and we further believe that the district court ruled properly in granting defendant's motion for summary judgment.
Thank you, Ms. Cantrell. Ms. Akins, anything further?
Yes, briefly, Your Honor. To respond to the last comment was made, they said they provided the accommodation, and I thought it was just the time off. But now they're saying they worked with her. These questions were asked by defense counsel at the deposition in the pages I mentioned. So going from 189 to 204 basically is where this discussion happens. And she asked, "Sir, did you give her did they offer rest breaks? Was there any modification to the job offered?" And she said no. She was not offered to do. There was no interactive process with respect to that job that she was doing. When they talk about the demotion, she says in her testimony that she refused to do it because it was more labor intensive. So what they tried to give her was something that was going to require her to be on the bench more, and she said no. She also specifically said at page 204 189 and 204 that she was not, when she asked about doing peer review, he said no, she wasn't able to do that. Nobody did any evaluation, and she vehemently denies that anybody said that she didn't do well at peer review. There was no one brought in to evaluate. Counsel asked her about that. So basically interactive process requiring you to have some type of evaluation done of your job site to say, well, here's how these things can be done. And to Judge Kohler's point before, that in terms of what would the accommodation be, that's the point of the interactive process, so that you could identify a way in which she would be able to do her job. This comment about the main goals not being met is a question of fact. If that's really what they're saying is the reason for not promoting her related to the vasopressin project, then that's a determination that a jury should make. I've not seen any evidence, and we certainly don't agree that that was the case. Also 29 CFR 1601-28 just requires that a notice of right to sue had been received, which it was. Just to address Your Honor's question with respect to whether we were disputing that, in our first argument, the reason that I laid out that there were right to sue letters because I'm letting the court know that she did receive a right to sue with respect to all of these. The charge, the letter after from the IDHR very clearly indicates all of the types of discrimination, age, national origin, disability, and retaliation were filed in November of 2019. So I would reject that. With respect to the diversity, there are 75 people in her department were Indian. She was of Chinese descent, and that's the nature of the accommodations that were given to other people of Indian descent that were not given to her. And for those reasons, I would just ask that the lower court be reversed. Thank you.
Thank you, Ms. Akins. Thanks to both counsel. The case will be taken under advisement.
Thank you.
Thank you.
The next case for oral argument this morning is Gordon Green versus David Leibowitz, appeal number 23-2841. Good morning, Mr. Stone.
Morning, Judge. How are you? Your Honors, my name is Matti Stone. I represent the appellant, debtor, Gordon Green. I'm requesting 1 minute for rebuttal. When I first started arguing this case, I would start my arguments by saying, you know, this is really complicated. We got 3 big statutes. They're really complicated. But at this point, I think that this is actually really simple. And I'll quote my own reply brief when I say, it looks like a duck, walks like a duck, it's probably a duck. If it looks like a retirement plan, it's probably a retirement
Is there a
plan.
tax benefit to your client?
Yes,
What is
absolutely.
it?
This is he can defer the income taxes on the monies which are placed in his account, similar to deferring monies placed into a retirement account in the U.S.
Like a regular IRA account?
Yeah, same thing. This account is basically the same thing as an American retirement account. It's just that all of the Internal Revenue Code sections that would deal with like an IRA or a 401k or a 403b have country of origin requirements. They talk about American plans. 404A, not sub A, 404 big A, is about foreign plans. But these foreign plans behave the same as the American plans. For all intents and purposes, it's the same thing. It's just in a foreign country.
Can I just confirm something with respect to your argument? At points in your briefing, you seem to be saying that as long as the plan meets 1006B, the definition of a retirement plan, that is sufficient. But do you agree that you also have to meet the requirement in 1006A1, namely that it's intended in good faith to qualify as a retirement plan under the applicable provisions of the Internal Revenue Code?
So I wouldn't describe it the way you did. 1006A is the standard. Intended in good faith to qualify as a retirement plan under the applicable provisions of the Internal Revenue Code. 1006B is explaining these are some things which would meet the requirements of 1006A. It's
So
not an
you
exhaustive
think
list.
your argument is that if it falls under B, that automatically meets A?
Yes. If something falls under B, then essentially the legislature has said these things meet A.
So if something falls under B, automatically it's then intended in good faith to qualify as a retirement plan under applicable provisions of the IRC.
Yes, I would say that. Yes, Judge.
Does that make the language under applicable provisions of the Internal Revenue Code of 1986 redundant?
No. 1006A is sort of unique amongst exemption statutes in that it has this broad catch-all. And the idea behind that is that the legislature realized that, you know, the code changes and we might miss something. We might be missing something now.
What's the broad catch-all, though? I think your argument is the broad catch-all is the definition of retirement plan in Section B.
I think the broad catch-all is anything which is intended in good faith to qualify as a retirement plan. So subsection B, these things are intended, but it's not an exhaustive list. The legislature is saying, we know this is not an exhaustive list. There could be other stuff that doesn't quite fit into one of these 4 categories.
But I got that, but then everything under B,
yes.
and everything under B plus additional things would automatically qualify as under applicable provisions in the Internal Revenue Code,
Everything under B would qualify as under applicable provisions in the Internal Revenue
which makes that language redundant.
again, I don't see how it makes it redundant to
It may be redundant. I mean, I'm just, it could be redundant, okay? I mean, it doesn't mean you lose if it is.
and to the extent that you know, a stock bonus pension I'm reading B1 right now. To the extent that a stock bonus plan, if B didn't exist, we'd still get the stock bonus plan in because it's intended in good faith, then yeah, B is redundant. If I meet A, I don't need B.
But I guess that sort of pushes the question if a retirement plan includes the following: a stock bonus plan. A stock bonus plan may have no tax benefits to an employee. Okay?
Sure.
And if it isn't under the applicable provisions of the Internal Revenue Code, that's why I started by talking about tax benefits. But you know, it seems to me that a retirement plan under the code requires tax benefits to the employee, not just the employer. And if that language is redundant, then a stock bonus plan, which has no tax benefits to the employee, could qualify as a retirement plan under Section 1006.
That's a fair point. There's no stock plan before the court right now. I should also point out that you have dicta in Weinhoft, and you have some lower cases, but I don't know that there's ever been a case before this court where, you know, is there a tax benefit is the guiding question on whether or not something would qualify. The only questions that have been.
But you're arguing that there is a tax benefit to the employee. So if there is a tax benefit, then your argument, I think, is you win, right? You qualify.
Right. But your question, Judge, about, well, the stock plan doesn't have a tax benefit, so fine, don't require a tax benefit. You know, if you look under Clark,
well, I don't know that we could do that. I mean, we have to follow the law.
Well, under Clark, the only question is, you know, is essentially, you know, is it set aside for retirement, right? And so when you look at Schinover and auto owners insurance, the active question is, are these funds in a segregated account? You know, where the money's set aside, you can't get to it until it's time to stop working, right? And that's also, if you look at legislative history, that's kind of what they're looking for, right? This is money that's set aside, so when this guy retires, he's not on the dole.
That is so broad, though. That means that I could create a savings account and say, well, this is set aside for retirement, so you can't attach this in bankruptcy, just because I say it is.
So, again, you're right, it's broad. Illinois statute is broad. Other states chose more narrow statutes. But
what do we do with the Illinois appellate court case in Brannett that says 1006 is meant to mirror section 522 of 11 USC?
Yeah, I don't
because
think
your
that,
argument doesn't mirror that.
Right. So I don't think that what Brannett meant there was that the exemptions are coextensive. I think what Brannett means to say there is that it's doing the same job as 522, right? You know, we have to list some exemptions. These are the
But
exemptions.
in Judge Kirsch's example, it wouldn't be doing the same job as 522.
How would it not be doing the same job? It's talking about what accounts are exempt.
If he creates some new account and says it's for retirement?
Well, if he creates a new account sort of out of thin air, right, then that would not be under an applicable provision of the Internal Revenue Code. And I think that's where the tax qualified terminology, which has kind of been used in the lower courts, but has never been defined and would be really helpful if the Seventh Circuit would define that, comes into play, is a plan which is intended in good faith to qualify as a retirement plan, period, does not meet 1006A, right? It has to be under the applicable provisions of the Internal Revenue Code. Our assertion is simply that 404A is one such applicable provision.
Do you agree that your account does not fall within any of the specifically identified provisions in 522, namely
Yes.
401, 403, et cetera?
Yes, 404A is not, 404 big A is not one of the enumerator provisions.
The question was just a little bit different than that. You agree, you're arguing it falls under 404A. I don't see you arguing that it falls under any of these other provisions.
I can't. You can't. Right. The reason why you can't, and this is sort of the central problem, right? All those other specific provisions have a country of origin requirement. What do you do about a foreign plan? What do you do about somebody who is in a foreign country when they earn their money and they set aside money for retirement and the IRS says, yeah, you know, we're going to defer taxation, we're going to give you deductions, you know, we're going to give you some preferred tax treatment, but it's a foreign country's plan. That's what 404A does. It's in that same subchapter D of the Internal Revenue Code, which talks about retirement plans. It's in that same bunch. Just for whatever reason, other statutes haven't brought it in. But Illinois has the
Does it
catch-all, so
matter
it'll bring it in.
that 404A only allows for deductions for the employer and not for the employee?
No, there's a special tax treatment. I see I'm at 1 minute,
Okay.
so I don't want to.
You could reserve that. Thank you.
Thank you, Judge.
Mr. Leibowitz?
Good morning, Your Honors. May it please the court, counsel. This case has been argued, I think, in the bankruptcy court and in the district court, and now here, and we're really kind of refining the arguments, but the arguments are the same all along. And what Mr. Stone has been arguing all along is that a qualified foreign plan, that's a word that does not have the word retirement in it, as a matter of fact, is the same as a tax qualified plan under the Internal Revenue Code.
Do you agree that the plan is a retirement plan as defined in 1006B?
No,
So you don't think it falls under?
I do not. I do not. And the reason is that that 506B includes certain things. And it's not one of those things that is included there. So no, if it's going to be included anywhere, it's got to be under C.
But I think you would not agree that just qualifying under B is sufficient to meet 1006A, would you?
I don't think this plan fits under B. Or,
If it did, would that alone be sufficient to meet A?
not necessarily, no. I would agree that it would not necessarily, because as Judge Kirsch, thank you, Your Honor.
That's okay.
Pointed out, someone could put together a plan that, is something that looks like a B, but doesn't have any tax attributes to it, and therefore it would not qualify under B. It's not our case, but I understand your question, Judge Sainty.
Are there tax benefits? Do you agree that there are tax benefits to the payer here, to the
Tax
debtor?
attributes, yes, there are tax attributes there. But it's not the same tax attributes that would exist as to, say, a 401k plan or a 403b plan. Or
How
whatever
so?
Tax well, because the tax contributions that are made are tax deductible to the employer, but the employee doesn't have any particular tax treatments under the Internal Revenue Code. They're under the Canadian Code, maybe.
But
I
so
think,
what? Isn't that the same as, I guess, a Roth IRA?
No, not at all, because a Roth IRA is something that's tax qualified under the Internal Revenue Code, and those deductions are deductible, and that would be protected under the Illinois.
Well, it would be protected, there's no question, but why, right? The why is because there are tax benefits to the employee, and
I understand your question, Judge Kirsch. The point here, though, that is, it goes to the question of intent, and clearly a Canadian drafter of a Canadian registered retirement savings plan was not thinking about trying to qualify or to have any attributes whatever under the Internal Revenue Code of the United States.
so what? What difference does that make? It either qualifies or it doesn't.
In order to qualify under the
I mean, we'd have to look at foreign lawmakers' intent to determine whether a retirement plan qualifies under the Internal Revenue Code.
Well, no, that's not the point. The point is whether or not the plan was drafted in order to qualify under the Internal Revenue
Who
Code.
cares if it wasn't? I
Well,
mean,
the state of
it
Illinois
either
cared
is
under
or
sub C,
isn't.
Your Honor.
What's that?
The state of Illinois cared under sub C. They said that a plan had to, in order to qualify, had to be a tax qualified plan under the Internal Revenue Code, which this is not. It's a foreign qualified plan which has certain attributes, but it doesn't have all of the attributes of a tax qualified plan under the Internal Revenue Code. As a matter of fact, as we pointed out in our brief, the Internal Revenue Service itself put out a revenue ruling in which it stated that an RRSP, the Canadian plan, is not a qualified plan for United States tax purposes. That was Revenue Ruling 89-95 in the 1989-2 Cumulative Bulletin cited in our brief. It's a different thing.
You are using tax attributes as opposed to tax benefits. I want to make sure
Tax attributes, that's
we're
right.
not losing the meaning, or that you're not trying to avoid a question about tax benefits.
I don't think it matters. I understand the question. I don't think it matters that there were some tax benefits to it under American law, under Canadian law, or otherwise. But it has to have certain tax attributes, Your Honor, in order to be qualified as a retirement plan under Illinois law. That's the whole point. So,
And how are you distinguishing tax attributes versus tax benefits?
well, because a plan under Section 401, 401K or 403B or any of the ones that are recognized by 522 of the Bankruptcy Code have not just tax benefits that you're talking about, Judge Kirsch, but also tax attributes. They qualified as such a plan under the United States law. We don't know what happens with respect to laws of other parts of the world. Maybe this Canadian plan does qualify as a foreign qualified plan, but we have commerce with innumerable countries in this here. People in the United States may work any part of the world.
But
and I
under
don't
our
think-
Internal Revenue Code, Joe Gill tells us we need to look and see whether or not this qualifies for one or more forms of preferred tax treatment. Now, maybe we won't follow Joe Gill, maybe we will, but does this have preferred tax treatment?
It has some tax treatment. Apparently, it qualifies as a foreign qualified plan. I don't think anyone disputes that it's a foreign qualified plan under 404A of the Internal Revenue Code, and it has such tax treatment as it has. But I don't think it's any different than Clark versus Ramaker, a plan for an inherited IRA has got certain tax treatment under the Internal Revenue Code, but it's not enough tax treatment under the Internal Revenue Code to qualify it to be exempt. And this is very similar, analogous to it. The fact that it has some tax treatment does not mean that it has the same tax attributes that are necessary in order for it to be a qualified retirement plan under the Internal Revenue Code, such as to give it the treatment that's provided in subsection C of 1001 of the Illinois statute. I have a little bit of time left, but I'm perfectly happy to answer what other questions. I think I've covered everything that I really needed to cover the brief, but I don't intend to burden you with additional talk unless there's some questions that you have, Your Honor.
I think we're good. Thank you. Mr. Stone?
So the trustee just mentioned Clark versus Ramaker, and I want to make something very clear. The reason why inherited IRAs were not exempt had nothing to do with their tax treatment. The reason why inherited IRAs were not exempt is because they weren't retirement plans. They weren't money set aside by the earner. They were an inheritance. And that's what Clark's definition of what a retirement plan is this person set aside his money for when he retires. That's not what was happening in an inherited IRA. That's what got put aside. There was no problem and no question in Clark about the tax treatment. There shouldn't be any question here. These plans are getting preferred tax treatment, and they are retirement plans. The trustee doesn't dispute that either. They should be entitled to the exemption.
Okay.
Thank you.
Thank you. The case will be taken under advisement. Thanks to both counsel. The next case for oral argument is appeal number 23-3031, People of the State of Illinois versus 3M Company. Whenever you're ready, Mr. Scodro. Good morning.
Good morning. Thank you, Your Honor. May it please the court, counsel. Michael Scodro on behalf of the defendant, appellant 3M. This court's decision in Baker is controlling and requires reversal of the remand order below. Indeed, at this point, the state says it would subtract out damages caused by AFFF PFAS in calculating damages when chemically identical AFFF PFAS and Cordova PFAS is commingled. But that's exactly what the plaintiffs tried to do in Baker, where this court correctly recognized that a federal court must perform those allocations. But in any event...
Counsel, wasn't Baker different? In Baker, they were talking about the Freon, backing out Freon, but there wasn't an acknowledgement that meant that they'd back out exposure to lead and arsenic. Here, we're not even necessarily talking about exposure paths. We're not talking about something where only part of it was disclaimed. We're talking about fixed sites and environmental claims.
Well, but Your Honor, in Baker, as in this case, the Freon was a source of the chemicals that were being challenged, just as here, AFFF houses precisely the same PFAS chemical, identical to the PFAS being talked about in the Cordova facility. So the sources, just as in that case, the sources of the self-same chemical are different. And the question is, which court ought to do that apportionment? And as this court correctly recognized in Baker, and you contrast it with the decision below in Baker, which, by the way, relies on a case like Kelleher, precisely the same authority being relied upon by the state in this case, it's clear that this court was rejecting the idea adopted by the district court in Baker that that apportionment is not part and parcel of the defense and isn't something that ought to be in front of a federal court. And I do want to add, Your Honor, that while we're talking about apportionment of damages and parts of the briefs are devoted to that, there's another argument at issue here too, which I think is logically prior, and that is looking at the complaint. The complaint also seeks significant injunctive relief, monitoring, remediation, air and water, investigation, public information. There's no suggestion as to how one could go about allocating injunctive relief in this case, consistent with, as we point out in our brief, page 218 in the record, A218, and the footnote on that page, which shows that in the trial court, even as to damages, putting aside injunctive relief, there was a stated effort on the part of the state to collect for an entire site or resource if some of the contamination there, some of the PFAS originated from the armory. So you really have two levels. The first is apportionment even going to be possible? Certainly not as to the injunctive relief, and that was, again, not the position of the state below, even as to damages. But even if you could, then we get to Baker. And Baker tells us that those complex apportionment decisions are for the courts to make. And it did so with good reason. Just prior to that in Baker, the Baker decision recognizes that with the 2011 amendment, relate to is now added to for, and the Congress was intending to broaden the scope of cases that would be brought into federal court where there was a potential for a federal officer argument to be raised, as it is here. And clearly, to put it in very simple terms, clearly the question of whether and to what extent a particular site is contaminated by or contains AFFF that is mil-spec from an armory, clearly that question relates to the production of mil-spec or the use of mil-spec at the armory. It seems self-evident.
Mr. Scotro, is 3M the only company that manufactures this mil-spec AFFF, or do other companies manufacture it?
So in the PFAS that's used in these products, and so there are multiple layers here, and in some of the cases around the country there are other defendants in play. So PFAS is produced or was produced by multiple companies, and there were also multiple sources of AFFF. Now certainly 3M, yes.
I'm sorry, certainly 3M, you're one of the producers, but not the sole producer.
Not the sole producer, but we...
So I didn't see anything here alleging that the mil-spec AFFF that was used at the Rock Island Arsenal was actually produced by 3M.
So, Your Honor, in our notice of removal treated as a pleading here, we certainly take on the responsibility for having been the producer of mil-spec at the armory. And
I don't want to waste your argument.
No, of course.
Maybe on rebuttal you could come back and just identify where that is, that it's clear that 3M is the producer, or alleging that it's the producer of the chemical at issue.
Of the chemical at issue, sure. Yeah. And I mean to be precise, a producer. I'm not suggesting we took on...
You clearly have stated that you were a producer of mil-spec AFFF, but I didn't see where you were alleged that you were a producer of the mil-spec AFFF used at the Rock Island Arsenal.
Okay. Well, that is certainly our position, Your Honor, and okay. I can represent that. I will come back with, yeah, that's
because obviously if you're not the producer
Correct.
Of it, all of your arguments go away.
Right. No, we have certainly, and it is certainly within the yes, I
okay.
will identify that.
Thank
but
you.
Certainly within the pleading, certainly has been our intent that is the plausible allegation in the notice of removal.
So if you prevail here, is every lawsuit involving the PFAS anywhere downriver of the Rock Island Arsenal removable against 3M removable to federal court?
If the claim is, if there is a plausible argument that, and that is the standard, there's a plausible allegation, and here we support it with, you know, the military's own, Army Corps' own report attached to our notice of removal. If there's an allegation that that mil-spec AFFF has commingled and that it's going to require disaggregation, and again here, as to the injunctive relief claims, I don't even know how you would start that. But even as the damages claim, where they're claiming that we can disaggregate, that would, under Baker, require a federal court to do that disaggregation. Now, I should note that, of course, they have the opportunity in responding to a notice of removal to argue, and to even in some plaintiffs have done so, to provide evidence to the contrary, that is not a plausible allegation. So, for example, an isolated, I'm going to make this up, an isolated pond for which there is no, you know, possible claim, no plausible argument within Twombly and Iqbal, the applicable standard, no plausible argument of co-contamination. Under those circumstances, then I think the court would be well within its rights to conclude that that was not plausibly alleged in the notice of removal. No disaggregation required under those circumstances. So, yes. So again, and I know I'm about to encroach on rebuttal time, but I do just want to close the opening by saying we really have two levels here. Again, one, it seems quite clear, as their own notice of remand, motion to remand made clear, 218 is the most obvious place. There will be instances, perhaps on the damages side, certainly on the injunctive relief side, where we will have to be spending money to remediate or otherwise, under their view, account for mil-spec AFFF. And even if all of that were apportionable, if we ignored the injunctive claims, we look solely at damages, even if one could disaggregate in the manner suggested, that's precisely what Baker requires to happen in a federal court.
Thank you. Ms. Johnny? Good morning.
Good morning, Your Honor, and may it please the Court. Assistant Attorney General Lee Jonig for the appellee, the State of Illinois. 3M failed to plausibly allege both the third and the fourth prong of federal officer removal for essentially the same reason, and that is that this case does not present any federal issue.
So let me ask you about that. Does that mean that the state of Illinois at trial will concede that if the toxins were commingled, there is no liability to 3M? None, zero.
If there's any particular place where the state cannot prove that contamination came from Cordova, then yes, the state
No,
would
I asked about commingling. You got to answer my question. I asked about commingling. If the toxins are commingled, does that mean that Illinois loses? Is that what you're going to tell the jury
Yes,
in the opening statement?
Yes, Your Honor.
There's
because-
no apportionment whatsoever.
Yes, and I think, I'm sorry, I think those things mean the same thing. 3M kind of keeps talking about commingling, but that's really just another way of saying that we will not have proved that contamination came from Cordova, right? If the source of the contamination...
No, not really. And I think your brief dances around this issue a little bit. I think there's a difference between saying that if there is commingling, 3M wins. Even it could be 5% from one facility and 95% from another facility. There is no apportionment. As long as that 5% came from facility A, 3M wins. Nobody will apportion the amount of contaminant that came from facility B. Is that your position?
Yes, Your Honor, and because I think that part of 3M's argument is really talking about commingling at a site, but the environment,
I think it's talking about commingling at multiple sites or commingling in the river, and I think I think they would be happy. I mean, I think with that concession they would be happy. I
Well-
think, but I didn't get that from the brief, that's the concession that you're making.
Well, our position is, perhaps there's some part of the environment where everything is all mixed up, it's all commingled, and we can't prove that contamination came from Cordova. There might be another part of the environment, maybe not in the river, but on the banks of the river, something like that, where we can prove that it came from Cordova. And in that instance, the state would recover, and it wouldn't implicate any federal
You'd have
issue.
to prove that 100% of the contamination came from Cordova, right? That you concede that.
Yes, I think 3M is kind of trying to say, well, we're just seeking to recover for contamination all in one place.
No, I
And-
think 3M's argument is different. I think 3M is saying, and I read this in your brief a little bit. I think 3M is saying that the state kind of wants to have it both ways. The state wants to be able to make an argument in the state court that there's commingling of these toxins, that some came from Cordova, but not all. And then the state court will have to apportion what amount came from Cordova and what amount came from other facilities. But I think it's different if, in opening statements, the state of Illinois says if 3M, if the state can't establish that all of the toxins came from another facility. In other words, if the state fails in its burden to establish that 100% of the toxins came from a different facility, 3M wins. Full stop.
So our position is still that we're talking about a lot of an area that's not, sort of a tiny place. So we might be able to prove that all of the contamination came from Cordova in one place, in which case we would recover, and in another place we couldn't prove that, and then we would not recover. That's our
Yeah, I
position.
got it. I mean, that's a big
and
concession.
I think, we've sort of been, 3M kind of makes this argument that we've been changing our position here, but I think we're just trying to say in as many ways as possible that this case is about, is contamination come from Cordova, or did it come from something else?
And-
If it came
and-
from...
Go
I'm
ahead.
sorry, go ahead.
But that totally distinguishes Baker, because it seems like these are two ships crossing in the night, at least the arguments, because what you're saying is Baker is totally irrelevant because there is no apportionment necessary in this case, period.
That's exactly right. In Baker, there was, the plaintiffs were seeking to recover for contamination from one Superfund site, and then they were trying to carve out, a piece that was due to federal activities. Here, what we're saying is we want to recover for contamination from Cordova. That's it. And so there's
I
nothing
had
really
this-
to carve out.
I had the same question as Judge Kirsch, and I just want to ask it a little bit differently to make sure I understand the state's position. So if 3M comes in, if you're talking about the water or the bank or any portion, and they show that there is AFFF in there, or I don't even think they have to show mil-spec AFFF. If they show that there's AFFF that's contaminated there, you will not seek to recover damages from that location, whether it's water, the bank, etc., because you've excluded that from what you're seeking.
Yes, that's what the complaint says. The complaint says we're seeking to recover for contamination that came from Cordova. So
And then the next question is, you would not ask the court or the jury at that point to say, well, sure, there might be some AFFF in there, but they've only proven that goes to 10% of the contamination. Cordova caused the other 90%, and therefore we can recover that 90%. Is that correct? You were not going to make an argument like that?
That's right. I mean, maybe there was some confusion in the briefing. I mean, again, we're talking about an area that's, there could be contamination over here from Cordova and not from over here. So we'd say to the jury, well, give us recovery for this part and not that part.
We just
and
want
so
to
when we
make
talk
clear that your argument about Cordova is not going to require any finder of fact to do any kind of apportionment about what may or may not have come from 3M or AFFF. And it sounds like you are agreeing you're not going to argue that.
That's right.
Okay.
Right. And importantly, this argument is the same whether, the something else that is not Cordova that caused any given contamination. It doesn't matter whether that is mil-spec AFFF, whether 3M made it, or whether it's a completely different chemical. If it's not from Cordova, then the state will not recover. That's why the state brought this case specifically about this one facility where we have a lot of information about, 3M and its manufacturing there, and so wanting to, get this one case moving as opposed to, these other cases about PFAS and AFFF where we have to do a lot more apportionment and fact-finding questions.
And counsel, you started that sentence with, if it's not from Cordova, we're not going to recover. I just want to retread this once more. What you're really saying is, if it's not all from Cordova, you're not going to recover. Is that accurate?
I mean, I guess, again, this sort of comes down to, like, what are we talking about, on a site? If over here at this part of the bank of the river, we can say that's all from Cordova, then we would recover. If over here we say, it cannot be determined, we can't prove that it came from Cordova, then we don't recover. I mean, when we're talking about all, I don't think it is not the state's position.
It's location specific.
Yes.
In each location, you have to prove it all came from Cordova.
Right, and at this point, early in the case, we can't say, what those locations are. That's all. So that's why I don't want to say, oh, if we can't prove it in one location, we're precluded from recovering in any other location.
I think it's
that is not the state's
where
position.
you put the all. I mean, we're putting the focus of all on
any particular location,
or the all on it. All has to be Cordova. That part of the contamination cannot be the AFFF at any location.
I'm sorry. I don't understand.
The all, you have to prove that whatever location you're talking about, that all of the damage there arose from the Cordova and nothing else.
That's correct.
Okay.
And that is what our complaint is alleged. That's what we argued in our brief in support of remand. We said this case is about contamination that was caused by Cordova. So what we have to prove in order to recover is that contamination was caused by Cordova. Maybe it's the whole area that we think is contaminated by Cordova. Maybe it's just one piece of it. Maybe it's none of it. We can't say at this point, but regardless of whether, regardless of the answer to that question, if it's not from Cordova, then the state won't recover, and we don't get into any questions of federal defenses over even what that thing that is not Cordova is. It doesn't even matter. And we made this argument many times in the district court. It's the same argument that we're making here, and sort of that there's been no change in position, and that's plain from the face of the complaint.
It seems that you are alleging your allegations here in order to avoid the MDL. Should that concern us at all?
No, because this is not, this case is not, it's very different from the cases that were presented, that were brought into the MDL. This is a case about a specific manufacturing facility where we have a lot of information about, what's being dumped into the river, what chemicals there are, how elevated the levels are, and the fact that 3M is the one that manages it, as opposed to the MDL, which has a lot of questions just about, there's many defendants even in that case about, where the PFAS got into what drinking water, who made it, what was the source. That's a lot of, and so we just didn't want this case to get bogged down into all of those fact-finding questions. And that's another reason why this doesn't present the claims, or the sort of artful pleading issues in Baker.
Thank you.
Unless the court, okay.
Mr. Scodro?
Thank you, Your Honor. To first address Your Honor's question, on page A33, which is page 14 of the removal papers, we say the state's claims for PFAS contamination of natural resources downstream from the Cordova facility plausibly arise in part from 3M's production and sale of AFFF manufactured according to military specifications established by the Department of Defense. Such mil-spec AFFF was then used, stored, and disposed by the U.S. military at installations in the state of Illinois, including at least the Rock Island Arsenal. So from there, Your Honor, we would say we have at least certainly plausibly alleged that we are the manufacturer.
Thank you for answering that.
I would like to address the point just made in the characterization. So just a couple quick points. First, there has been a change. As we point out, on A218, the argument was actually made in their remand papers saying that it is not an argument that 3M should be excused from liability for damages caused by the U.S. Army's discharge of mil-spec AFFF, and then a footnote discussing joint and several liability. As the briefs, I think, acknowledge that isn't the precisely correct term, but the notion was that there would have been liability assigned more broadly. And
not anymore.
Well, and so
I mean,
I'll
you had to get what you wanted there.
I'll just end by saying, Your Honor, during the exchange, there was a discussion of this part and that part. The term location was used, and then the reference to just one piece. And I guess I would just say that if Baker is talking about the need for a complex factual determination, the sort of small piece allocation, it's unclear at what micro level that's occurring, is itself precisely what Baker is talking about, and talking about the need for those kinds of allocations to occur in federal court. So I don't see a distinction, although obviously if, and you know, the same would go for, and I realize I'm over my time.
Go ahead, you can finish answering.
Thank you, Your Honor. Thank you, Your Honor. The same would go for the remedial measures. It's hard to imagine that the remedial measures, including cleaning groundwater, for example, or the other types that are talked about, even air remediation, how that could occur on the kind of micro place location level we're talking about. And again, I just think all of that suggests that that's exactly the concern that Baker had in mind in discussing complex factual determination. Something they have said in their brief a couple of times correctly would require complex.
Thank you, Mr. Scodro.
Thank you, Your Honor.
The court will take the case under advisement. Thanks to both counsel. The final case for argument this morning is Appeal 24-1006, Indiana Land Trust 3082 versus Hammond Redevelopment. Morning, Mr. Carroll.
Good morning, Your Honor. Good morning. May it please the court. Jeff Carroll on behalf of the appellants, Land Trust, also refer to them as the Abazirs who benefit from the trust. So the Abazirs are today appealing the district court's dismissal, the Indiana Northern District's dismissal of multiple constitutional claims related to what's really a basic, pretty basic set of alleged facts.
Sorry to interrupt you, Mr.
Sure, Your
Carroll, but
Honor.
before you go too far, could you tell us, please, what the status of the state condemnation proceedings is? I know at the time of briefing they were still ongoing. Has anything changed?
No, nothing's changed, Your Honor. No.
Thank you.
No. So the district court dismissed the Abazirs' substantive due process claim via an order dated last April, and then later we amended that complaint, and then that later amended complaint pleading or alleging equal protection violations that was dismissed via an order in December of 2023. Final judgment entered shortly after. The Abazirs own a fireworks store in Hammond, Indiana. It's down the road near the Illinois state line. The store sits on a major north-south street in Lake County, Indiana. That's Indianapolis Boulevard. Behind the boulevard and the Abazir store to their west is a residential area known as the Water Gardens neighborhood of Hammond, Indiana. The defendants, which include the Hammond Redevelopment Commission, the mayor of Hammond, the city, and various employees in their individual and official capacities, have attempted to exercise their Indiana state eminent domain power to condemn the property that the building, this fireworks and tobacco store, sits upon, purportedly to construct a road, an alleyway that connects the neighborhood and a boulevard. As alleged in our complaint, and this is important, the road was never intended to be built, and defendants actually seek, the other fact that's relevant here is that defendants seek to take an entire parcel rather than just the area that would be needed to connect this alley to the roadway, the neighborhood to the roadway, excuse me. So the Abazirs' core allegation here is that they're being targeted by the defendants because they're not political supporters of the mayor of Hammond, and that the condemnation would in fact benefit the mayor's political supporters Some of those political supporters.
Whether the road is intended, why is that not an argument that should be made to the state court? That the road is not intended to be built? I mean, for us, that doesn't make any difference whatsoever. I mean, I don't think under our case law, it doesn't matter. As long as Hammond says we intend to build the road, that's it for us.
So we are making that argument at the state court level in response to the taking,
Right.
Your Honor knows, and then the state court said
And they haven't taken anything yet here, so you have a real trouble with a substantive due process claim because they haven't done anything.
They have. So our claim is that, as Your Honor stated, that they're never going to build the road, right?
Right. And maybe they won't.
And we've pled that they don't intend to build the road.
And maybe they don't.
Right. So.
But why does that matter for the federal court?
So that matters for the federal court because I think at that point it would swallow the entire ability to challenge any such taking.
In federal court, but not in state court. Because I think you can challenge the condemnation proceedings in state court by saying that this is not their intent. They don't intend to build a road. They can't put a road here. Whatever. They can't put a road, okay? There's a river. You can't put a road. That would affect the condemnation proceedings, but that would not create a substantive due process claim.
We think it would because our argument is that it would, the idea that, I mean, the standard for a substantive due process claim is that it shocks the conscience, correct? And so our argument is that if the city or any government entity is making the claim, is condemning property because for saying they're going to build a road when in fact they're never going to build a road, that would shock the conscience right there.
But what's the substantive due process right at issue? It can't just be shocks the conscience. In order to have a substantive due process claim, you have to have the recognized right up front. And it can't be the taking because nothing's been taken yet.
Well, I think that the substantive due process right.
What's the protected life, liberty, or property at issue for your substantive due process claim?
To not have the property, I guess, condemned for false
It's a
purposes.
taking. Nothing's been taken yet. So it doesn't seem like you have a protected life, liberty, or property at issue in order to make the due process shocks the conscience argument.
So our argument, Your Honor, is that the process itself, being subjected to the process itself, damages
The Supreme
property
Court
owner.
has been very clear that substantive due process is a limited area and we should not expand it. Is there any case that supports what you're now claiming is your protected life, liberty, or property at issue?
Regarding the substantive due process, Your Honor, I admit that I do not have one handy for me right now. But we've also made an equal protection argument.
And isn't the equal protection argument essentially there can't be a rational basis because they didn't follow the law, and there's no rational basis not to follow the law? Isn't that where every taking is going to wind up somehow in federal court now?
No, because the equal protection argument is that there are similarly situated properties, right? So this stretch of road has you have the fireworks store here on Indianapolis Boulevard in Hammond. To the south of that, you have vacant land that goes on for blocks and blocks. North of that, you have vacant lot property that goes on for blocks and blocks. Part of that vacant property also includes a pathway that is still owned by the city that once did contain that was once a roadway connecting the neighborhood to Indianapolis Boulevard. So no, I don't think that every single taking would implicate equal protection because you're not always going to have the instance where you have similarly situated comparators who are not being treated the same way. That's what brings it under equal protection.
Do you want to save the rest of your time for rebuttal, Mr. Bureau? It's up to you. You're into your rebuttal
Sure.
time.
I'm just
Yeah,
making
it's
sure
up
that
to
I
you.
know the clock's ticking, right, Your Honor? Yeah, I will, but let me just to close on the equal protection in particular. So the argument is we have the fireworks store here. There's all this land that's way more conducive to this, and yet we're being targeted out of political animus and to benefit not only the surrounding property owners, But also the mayor's, another of the mayor's supporters is a fireworks store owner in the city, so it would benefit him as well. He's not a comparator because he's not similarly situated, but our contention is that we are, you know, the Abazir's fireworks store is being targeted. They don't need that much land, and there's land they already own that they could put this, that's better, and there's land, vacant land, that would serve the purpose more so, and we're simply being targeted to benefit a private purpose. Thank you.
Thank you, Mr. Carroll. Mr. Johnson, good morning.
Good morning, may it please the court. Of course, that's the oldest argument for every landowner. Make sure that that public improvement is put on somebody else's land. As you can tell by reading the briefs, and particularly the appellant's brief and their reply, it's generously larded with references to Indiana state decisions dealing with the exercise of the power of eminent domain. They are in court, in the Lake Superior Court, having asserted a number of objections to the taking. And they cite here cases from the state of Indiana which provide that if you have an ill motive, if you have a bad motive, if you're taking more property than you're entitled to, if you are not taking it for a public use but rather for a private use, all of those are properly asserted objections under the 1911 Eminent Domain Act, and those will defeat the take. All you have to do is read one of the cases they cite, Derloshen, which is from the 1968 Indiana Supreme Court. And there those objections are made. The trial court says we're not going to hear them, and the Supreme Court said if these objections carry the day, this take, City of Fort Wayne, is defeated because you are taking for using the public power to take for the benefit of a stainless steel company, and that's a private use. All of that is in their briefs. So what they basically are trying to do is infuse into a constitutional case, the constitutional issues are not there, Indiana eminent domain law, which they have a clear opportunity to present to the trial court. And that, of course, defeats the substantive due process claim, because whether we go back to Bettendorf, to Synergy, to 145 LLC, I think it's Fisk LLC, decided in 2021. All of those cases provide that if you're making a substantive due process claim and you have a state remedy, you have to comply with the state remedy. And Synergy decided in 2014, the court there says, you know, you could have filed a writ of mandamus, Mr. Appellant. Well, this isn't the case here. This is a recognized action commenced by the city to exercise its statutory rights, and you're in that case defending, making the very same objections that you're making here. So the substantive due process claim, which was resolved by the district court on a futility issue with regard to their third amended complaint, was basically that you have to show under the due process clause that the actions taken against your property are arbitrary and irrational, or they shock the conscience. And the court there said, exercising your power of eminent domain is a legitimate state action, and that is rational. But there's a better way, I think, to resolve all of this by looking at Bettendorf, at Synergy, at 145 Fisk LLC, which say if there is a state procedure that is available to you, you don't have a substantive due process claim. Now, with regard to the equal protection, the class of one claim, that too can be resolved on the basis of the legitimacy, the rationality of the exercise of the power of eminent domain. And here, the appellants completely fuzz over what the standard is. The court below properly analyzed whether or not there is a rational basis, because there is no suspect class, because there's no fundamental right here. So we're dealing with a rational basis analysis for why was my property picked and not the guy next door or the guy down the street. And what the court there looked at was, are there comparators? It didn't find any, but it really focused on the issue of rationality. And remember, Flying J, which was decided by this court, it's I think at 549 Fed 3rd, 547, the court says the court's job is to look at any conceivable rational basis. any conceivable rational basis. And so the district court below reached a very simple conclusion. It is a conceivable rational basis for the city of Hammond to want to condemn this property in order to provide a roadway that would connect the Water Gardens part of the Robertsdale subdivision in the city of Hammond with Indianapolis Boulevard. And in order to do that, they're going to require going through your property. Then the issue becomes, well, and you heard it already today, you're taking too much. You shouldn't take as much. Well, that's the offices of eminent domain, and that's going to be an issue that's going to be decided by the state court. You should locate it somewhere else. We've been targeted. Well, that's also an issue for the state court to decide where this improvement is going to be located. And, oh, by the way, if you're taking it for a private use, you can't do it. Der Lawschen allows you to argue that and to present evidence with regard to that. And you cannot take the property and then not put the improvement in. The statute specifically provides for that. So for this case to be in federal court, we have to turn local property law upside down. And we have to make this court, or the court below, a state court with regard to determining the wisdom and the necessity of a taking. And I think the courts have been pretty clear that that is not a proper office for a federal court, and it certainly doesn't amount to some sort of constitutional violation. There isn't a constitutional violation here. And the only one that's cognizable, the only one that makes any sense in this context is, of course, the Fifth Amendment, the right to just compensation. And these folks are going to receive just compensation. There's only two things that can happen to them, neither of which amount to a constitutional injury. The proceedings in the Lake Superior Court are going to go forward, and they're going to prevail. If they prevail, there's no taking. Proceedings go forward, and the city prevails. The city doesn't get to take the property until it pays the award of appraisers. In other words, this isn't a regulatory taking. This isn't an exaction. The city hasn't taken anything, and they can't take anything unless they pay compensation. And under the statute, the city can't even enter the property until they pay the award of the appraisers, and that doesn't stop the landowner from going forward, filing exceptions and having a jury trial on the inadequacy of the amount of money so that they can get even more.
Is the state proceeding stayed?
No.
While this is going
No,
on?
no one.
It doesn't look like anything has moved.
Yeah. No one has moved. That's the better way to put it. There's been no formal action. This matter, for want of a better term, I think everyone is giving it priority in order to have it resolved before we go forward with the state proceedings. There's just no constitutional issue here. No taking, no injury. The Fifth Amendment controls, the statute protects them, and they'll have every right to do whatever they have to be done. And trying to shoehorn this into substantive due process or trying to shoehorn it into equal protection for a class of one simply doesn't work.
Thank you. Mr. Carroll.
Briefly, Your Honor, just a couple points to hit following Appellee's argument. Appellee mentioned the Flying J case. It's rational if there's any conceivable rational basis. In this case, the rational basis provided, which is the building of a roadway. We don't contest. Look, building of a road that's a public purpose. That's what government does. They build schools. They build roads. They preside over court cases. Our complaint, the Abazir's complaint, alleges again that there's not going to be a roadway built. It's never going to happen. That's the allegation of the complaint has to be taken as true. The district court then supplied the rational basis that contradicts that allegation. So that's our argument. Not that a roadway is not a proper purpose. Of course it is, but we're saying that roadway is never going to be built. That's the allegation. We can go to discovery. We can figure out whether that road's ever going to be built. But our allegation that should survive a 12B6 motion is that the road's never going to be built. As far as just compensation goes, sure, in the state court, if the Abazirs win, or excuse me, if they win, it never gets built, right? If they lose, they get just compensation. But just compensation doesn't make them whole for the constitutional violations that we're alleging here, which are that, you know, equal protection, substantive due process. Those have value as well, whether they're nominal, and then the jury can decide what the value of that constitutional deprivation is. We'll see, but that's a jury issue. Just compensation doesn't take care of it all. So, thank you.
Thank you. Thanks to both counsel. The court will take the case under advisement, and that concludes our oral arguments for this morning.